May I please, Lord? In respect of item number 19, two numbers of petition and applications. Filed on 12/12/2025, which is not on record. May I call for it?
Item number 19.
Yes, Lord.
Okay. Yes,
May I please, your Lordship? Lordship, back to mention item number 21, Lordship. Lordship, as per last order, Lordship, cost title amendment, we have submitted, Lordship, yesterday only. That is not on record, Lordship. Another date after vacation, Lordship. Also the
okay.
name of
On the
the
pair being made by Mr.
A Mena, Lordship.
Learned Counsel for the applicant. Recessal is the matter after vacation.
A date may be fixed, Lordship.
22nd January.
May I Lordship, my
Yes.
lord, I beg to mention item number 14 with due consent from the other side. My lord, I pray for some time to file my reply in this matter. 1/4/14.
Miss
Tiwa Pangla.
Learned Counsel for the petitioner with consent from the other side, press for listing the matter after vacation.
Petitioner.
Vacation so as to enable her to file a reply to the affidavit in opposition filed by the state respondent.
My lord.
Fair Lord.
Item number 6, I'm the petitioner. It's and file our reply to the affidavit filed by the respondent number 2.
Miss
Kebura,
Learned Counsel
for the petitioner.
for the petitioner with consent from the other side, press for listing the matter after vacation so as to enable her to file a reply to the affidavit in opposition filed by the state respondent. Fair Lord. Recessal is the matter after vacation.
Lordship, I beg to mention for listing for admission, Lordship, on Friday.
Senior Court.
Main page about it. So I'd like to mention item number 16. Senior counsel, the order does is our station on our public purpose. I adjourn this matter and until after vacation, after vacation.
Mr.
Mr. I. Bhuya,
I. Bhuya, Learned Counsel appearing on behalf of Mr.
respondent 2, 3, and 7.
Lordship, I'm representing on behalf of Mr. Fukan for respondent number 6.
Okay. You are for respondent number
6.
2, 3, and 7.
Yes.
With consent from the other side, you inform the other side.
Hello, we are for the petition. my lord.
With consent from the other side, press for listing the matter after.
Lordship, 20th of January.
Okay.
My lord, we have an interim order, my lord.
Okay. Interim order pass earlier shall continue.
Much obliged, my lord.
May I please, Lordship? I beg to mention item number 12. Lordship, kindly adjourn the matter for the day.
For the day,
For the day.
Miss, your name,
MSE Devi,
Learned Counsel appearing on behalf of
Mr. MSEC.
MSEC, Learned Counsel for the petitioner with consent from the other side. Price for adjournment of the matter for the day. Fair allowed. The matter stands adjourned for the day.
I plead your lordship, my lord. Item number 19 may be listed after vacation, my lord. I have to file affidavit in reply.
19. Did you inform the other side? Did you inform the other side?
Yes.
Inform.
My-
No.
I may inform, my lord, but they have filed affidavit. I have
Yes.
received the copy today only.
Okay.
That's why I'm making the prayer, my lord.
Okay. Okay. Mr. C. Soruri, Learned Senior Counsel, assisted by Learned Counsel for the petitioner. With consent from the other side, price for listing the matter after vacation.
After vacation.
After vacation, so as to enable him to file reply to the affidavit in opposition. No, reply to the affidavit filed by the respondents.
Respondent.
Fair allowed.
Obligement.
Item for motion, item number 1.
May I please, your lordship? My lord, petitioner before your lordship, my lord, is basically aggrieved by rejection of his candidature for non-submission of OBC non-criminal certificate on the date fixed, my lord. So if I may take your lordship to the advertisement first, my lord. That my lord finds
Page
at
number?
page 22 of the writ petition.
Yes.
At the top of the page, my lord, just to indicate, my lord, what are the posts meant for, my lord. Constable, notice, my lord. Constable GD in general duty in Central Armed Police Forces, CAPF and SSF, Rifleman GD in Assam Rifles, SIPO in Narcotics Control Bureau, examination 2025. So if my lord turns to the next page, page 23, there is a chart, my lord. At the bottom of the page, there is a chart, my lord, indicating vacancy positions. If we, my lord, come to the fourth column, my lord, it is OBC. In all services, my lord, total number of vacancy was, my lord, 7747. At the bottom of that column, my lord, 7,747. Now, my lord, there are other criteria. I would like to take your lordship to clause number 5, next page, my lord, page 24. This is age limit, my lord. Age limit. The crucial, clause number 5, age limit. The crucial date for age reckoning is fixed on 1/1/2025. 1/1/25 in accordance with the provisions of DOPT OM number so and so dated 14/7/1988. Accordingly, the age of the candidate must be 18 to 23 years as on 1/1/2025. That is candidate born not before 2/1/2002 and not later 1/10/2007. So bracket is 2002 to 2007, my lord. If we now see the chart, my lord, again, table, code number 2, serial OBC, 5.1 clause, my lord. Permissible relaxation in upper age limit for different categories.
Clause
as
number,
under
clause number.
5.1, my lord, just
Hmm.
next to the age limit, my lord.
Yes, yes.
Permissible relaxation of upper age limit for different categories as under. Column number 1, my lord, say serial number 2, OBC. It is relaxation is permissible by 3 years, my lord.
Hmm.
Upper age limit. So, my lord, the bracket was 2/1/2002 to 1/7/2007. In respect of OBC, my lord, we can go back to 1999. That will not be so relevant in this case, but since they have, my lord, indicated that also, that's why I have pointed out, my lord. Next, if I may take your lordship to page 27, my lord. Page 27, clause number 6, process of certification and format of certificates.
Yes.
Candidates who wish to be considered against reserve vacancies or seek age relaxation are required to submit the requisite certificate from the competent authority in the prescribed format when such certificates are sought by the CAPF, Central Armed Police Forces, my lord, concerned for document verification at the time of DME. DME means, my lord, detailed medical examination. That is the last phase of the examination. Otherwise, their claim for SC, ST, OBC, EWS, ESM category will not be entertained, and their candidature applications will be considered under unreserved category. Further, if a candidate has sought any overage relaxation or claim so and so and is not able to produce the relevant certificate, he will be considered in his respective category of so and so. Now, my lord, may kindly peruse clause 6.5, my lord, that same page, second paragraph from bottom. The crucial date for claim of ST, SC, OBC, EWS. My lord, will kindly note, I belong to OBC. They say, my lord, the crucial date for claim of SC, ST, OBC, only OBC, my lord. No, nothing added to OBC, my lord. Status or any other benefit, that is fee concession, reservation, age relaxation will be the closing date of receipt of the online application form, that is 14/10/2024. So 14/10/2024, I have to make a claim that I belong to OBC, my lord. Next clause, my lord. A person seeking an appointment on the basis of reservation to OBC must ensure that he possesses the caste community certificate and does not fall in the creamy layer on the crucial date. He has to indicate, my lord, that he doesn't fall under creamy layer on that he was not a person belonging to creamy layer, my lord. So accordingly, my lord, I participated. I cleared everything, my lord, during the verification. Before that, my lord, may kindly peruse. Page 30, my lord. Annexure C. Page 30 is my caste certificate. Jatir Praman Patra, caste certificate. I will read the English portion, my lord. First one is Assamese. This is to certify that Sri Sampak Roy, son, daughter of so-and-so, village so-and-so, PO so-and-so, district Bongaigaon, in the state of Assam, belongs to Koch Rajbangshi caste community, which is recognized as other backward class stroke MOBC class by government of Assam. So there is no dispute that I belong to OBC. And my lord, my belongingness to a caste, my lord, there are several judgments, my lord, is not dependent upon the certificate. It depends whenever a person born in a caste, that is the essence, my lord. Certificate is not the essence. Anyway, my lord, this certificate is dated, my lord, you'll see at the top 18/11/2023. So while submitting, my lord, I submitted this document also. Admit cards were issued. I participated. But my lord, what they have done at page 31. Page 31 is my rejection, my lord. It is dated, my lord, will kindly take note of the date. It is relevant. 1/12/2025. Very recently, my lord. The candidature for the post of so-and-so is hereby rejected on the following grounds. The ground is at serial number 6, my lord. Any other discrepancy notice. Date of birth is 2010-2000. My lord, got it, my lord. Date of birth is 2010-2000 and the age as on 1/1/2025 is 24 years. 2 months and 13 days. OBC non-creamy layer certificate as on 14/10/2024 not produced, due to which you are over age and not eligible to get relaxation of OBC. So my lord, if I could submit not only the OBC certificate, the non-creamy layer belonging to non-creamy layer section, my lord, my candidature would have been considered. In that situation, my lord, I was entitled for grant of relaxation of 3 years, up to 3 years. My overage would not have been a condition of rejection, my lord. That's why they say, due to which you are overage and not eligible to get relaxation of OBC, because there was want of non-creamy layer certificate. If my lord now perishes page 29, my lord, it is, my lord, dated 1/12/2025. Last rejection, my lord. It is now, my lord, you see. এখন কি ছিলাম এখন এখন শিডিউল কাস্টে হয়তো
Schedule caste.
এর নন ক্রিমিনাল না এটা
Non-criminal, OBC.
নন ক্রিমিনাল লেখা আছে এটা
Here, follow লেখা আছে।
কোন কোন yes it is dated 16/5 before much before my rejection, my lord. It was submitted 16/5/2025. It was issued by DC Bongaigaon. English portion at the last paragraph, my lord. Champak Roy and or his family originally resides in, has my lord got it, my lord, resides in Bongaigaon District Division, Assam State. This is also to certify that she does not belong to persons sections creamy layer mentioned in column 3 of the schedule to the Government of India Department of Personnel so-and-so, which is modified by so-and-so and further modified by so-and-so or the last so-and-so. So I submitted my creamy layer certificate much prior to my rejection, my lord. They refused to consider it, my lord. On the pretext, my lord, I did not submit it on the date they indicated in the advertisement, which my lord again finds at page 27, my lord. If my lord perishes page 27, clause 6.5, it says crucial date for claim of SC, ST, OBC, economically weaker section. It nowhere says, my lord, non-creamy layer certificate has to be submitted on that day. It
Okay,
says,
but if a candidate has to produce that OBC candidate has to produce the non-creamy layer certificate, then you have failed to produce it on the relevant date,
my lord,
10/4/2024. This certificate is updated 16/5/2025.
25. Non-creamy layer certificate I obtained later, my lord, but my belongingness to OBC, that OBC certificate is of 2023. That I submitted because this clause says certificate of OBC. Second clause says, my lord, you see now, a person seeking an appointment on the basis of reservation to OBC must ensure that he possesses certificate, community certificate, and does not fall in the creamy layer on the crucial date. I do not fall in the creamy layer. That certificate I submitted later on. There is no indication that that has to be submitted on 14/10/2024. I submitted OBC as was mandated here on that day. Thereafter, my lord, I approached the DC Bongaigaon. He also, my lord, gave a certificate. Because non-creamy layer, my lord, has to be for 1 year. That certificate's validity is for 1 year. 1 year validity, my lord. So that
Maybe if we go by the terms and condition in the advertisement, then on the relevant date, you do not possess the
non-creamy,
non-creamy layer certificate.
yes, no denial to that, my lord. I
Hmm.
possess the OBC certificate.
Then if you fail to satisfy the requirement of the advertisement, then.
Yes, my lord. In fact, my lord, identical situation, my lord, arose in Delhi and Kerala.
Hmm.
There were writ petitions filed in respect of All India Ministry of Medical Sciences also. Writ petition was allowed. It says that non-criminal certification, there cannot be a stipulated date. That is wrong. Then the matter went up to Honorable Supreme Court. Honorable Supreme Court also upheld the High Court's decision, my lord. There are two judgments, one Delhi High Court, one Kerala High Court, my lord. If my lord perishes page 32, my lord. Essence is, my lord, my belongingness to a community, not the date of certification. Essence is, my lord, that I belong to non-criminal. I'm economically poor, my lord. That is the essence, not the date of certification. Page 32, my lord, may see. We approach the DC immediately, my lord, to give us a non-criminal certificate. To, my lord, just validate, my lord, our claim. Last paragraph, my lord, may see.
Hmm.
Page 32, last page of the writ petition.
Hmm.
My name is at serial number 2, Champak Roy. Last paragraph. As such, considering the fact that the appearing candidates genuinely belong to the OBC community since their birth and are certified as belonging to non-criminal category as per financial report of 2024-25, the candidate may be allowed to appear in the test so that they can get an opportunity to qualify the examination. So there is no denial that in 2024-25 financial year, I belong to non-criminal. That was the mandate, my lord. Non-criminal certificates are issued for a year, my lord. So only because,
No,
my lord,
maybe, why you could not obtain the same during the year 2024
my lord,
as per advertisement?
it is true, my lord. I could not obtain.
Hmm. Then,
There is no denial, but not obtaining, my lord, will not result in denial of my candidature, my lord. Because I obtained OBC certificate I submitted. I was to ensure that I belong to non-criminal, to ensure that, my lord, I obtained in the month of May 2025. I'm holding that, my lord. If my lord now perishes, Ram Kumar was not heard. File to my kuchori chahiye tomorke. Delhi High Court to Ravi Kumar was not. No, more file out. Ravi Kumar. Ravi Kumar second to the copy. Ravi Kumar. Anikan. Delhi High Court. In division bench, single bench. There is a judgment of Honorable Delhi High Court, which was upheld by Honorable Supreme Court, my lord. It will come to division bench.
maybe, but there are several decisions of the Supreme Court that on the date of advertisement or the date stipulated therein, the candidate must have the requisite qualification.
Exactly, my lord. No denial to that.
Then,
Requisite qualification of, my lord, educational qualification is that is the law, my lord. I may not have educational qualification on that day, but my belongingness to a category of special category of
no,
person.
you are OBC, all right, but you don't possess, don't have the non-criminal certificate on the date of advertisement. You procured it later on.
Yes, my lord.
Hmm?
That can be done, my lord. That is why I wanted to take a lordship to the judgment, my lord.
No, you produce any decision of the Supreme Court on that
My lord,
point.
decision of the Supreme Court is that while this case was appealed in the Supreme Court by the government, my lord, it was
Maybe
dismissed by
whether any proposition of law is laid
yes,
down in that.
proposition of law is laid down
No,
here,
no,
my
no,
lord.
in the Supreme Court decision.
Supreme Court has upheld the proposition of
No,
law
no.
laid down here, my lord. My lord, kindly appreciate one thing. Division bench has said it is permissible. The state went on appeal to Supreme Court. Supreme Court has dismissed the appeal of the state in limine. Meaning thereby, my lord, that
So, madam, better you do one thing, you obtain instruction as to whether this can be considered at this stage or not, this non-criminal certificate.
Before the ordinance of this court.
When?
In courts.
I think no order was passed, my lord. in that.
No, maybe, but here you obtain instruction as to whether at this stage this criminal or non-criminal certificate can be considered. or not. You, Mr. Goswami, you furnish a copy of the decision of the Delhi High Court to her
Yes, my lord.
so
Yes.
that she can obtain instruction in that regard.
Specifically said, my lord, qualification as regard education has to be on the date of submission of application,
That's all right, you furnish a copy to her.
not the caste certificate, my lord. Yes,
You, on Friday, we'll take it up, you obtain instruction in the
my
meantime.
lord.
No, after vacation,
For entire writ petition will become infractions, my lord.
maybe New Delhi is, you will get the instruction.
But then, my lord, one post may be kept vacant, my lord. There are so many posts. One, otherwise, my lord, repetition will become infraction. Exactly identical case, my lord. There is a, my lord, if my lord, there is a small judgment, my lord, Honorable Kerala High Court, my lord. Very small judgment.
No,
Well, but
furnish a
kindly-
copy to her.
Yes, I have given her a copy, my lord.
Heard Mr. P. Goswami, learned counsel for the petitioner, Ms. Borua for learned CGC.
Yes, sir.
CGC. This petition under Article 226 of the Constitution of India, the petitioner has challenged the communication dated 1/12/2025 issued by the member of the recruitment board DV stroke DM stroke RME dash cities within bracket GD. Exam dash 2025 center dash CAPFS CHPSF Patgaon, Guwahati. It is to be noted here that by the impugn communication dated so and so, the respondent authorities have rejected the candidature of the petitioner for being appointed to the post of constable stroke GD examination. GD. On the ground that date of birth is 28/10/2000 and age as on 1/1/2025 is 24 years, 2 months and 13 days. Stroke, no, full stop. OBC non-creamy layer certificate as on date 14/10/2024 not produced due to which you are due to which his overage he is overage and not eligible to get relaxation of OBC. Relaxation of OBC. First, the petition and the documents placed on record. List the matter on Friday. In the meantime, Ms. Borua learned CGC shall obtain instruction as to whether the criminal certificate, non-criminal certificate dated 16/5/2025, which the petitioner has produced. When you have produced this letter of this certificate?
Immediately on my lord, issue, my lord, on the month of May itself, my lord, 16/5/2025.
In the month of May 2025.
25, my lord.
25 can be considered in view of the decision rendered by Delhi High Court in the case of
My lord, civil appeal number 1691.
you furnish 2 copy to the
Yes, my lord. My lord, Delhi High Court and available Honorable Supreme Court, my lord.
accordingly. Let's list the matter on Friday.
Supreme Court to develop, can you believe? But item 3 will be same, my lord. Identical order, my lord.
Okay.
It's simple order to go to Delhi High Court. There is no order, but Supreme Court order to SL.
We were engaged as usual worker in the forest department under Chirang Forest, Chirang Division, my lord. We have completed more than 40 years, my lord, in continuous service, my lord. But we have not been paid the minimum scale of pay, my lord. Therefore, I have approved before this honorable court for seeking the minimum pay scale, my lord, which was passed in other similar matter, my lord. My other similar matter in WBC number 5/8/14/2024 and WBC number 4196/2025, my lord. So my case may be disposed of in the light of the other similar matter passed in WBC number.
Yes, Mr. Musahani.
I need to obtain so far petitioner's name are shown out of the petitioner worship. Only 2 petitioners' name in that casual worker list. No, please come to page number 46. 27 Lord.
Page number?
Page number 27 also. Nasir Ali is the petitioner number 6 Lord. Manik Chandra.
Manik Das,
is
Manik
the
Das.
petitioner number 7. Out of wait, yeah, only petitioner name are shown as casual worker. All except Lordship. We look at page number 19 Lordship. And it's not 19. Lordship, I really report goes. One of the tickets are received from summary Lordship, service provider. That is a Lordship.
Musahari, kindly see my lord, page 16 my lord. Musahari was engaged as casual worker. His engagement certificate kindly see my lord. This is certified that Vishitra Musahari, son of Sasan sir, village Sasan sir, district Sirang, DTR, Assam. He is working as a casual labor in the forest department of BTC for the purpose of protection of forest and wildlife under Kuklung Ranch, Kuklung, Sirang Division, Kajolgaon, since 10/11/2006, my lord. This is his experience certificate, my lord, issued by the Ranch Forest Officer, Kuklung Ranch. The page 19 means he was engaged also as a driver, my lord, of forest department. That is why a I-card was issued to Musahari, my lord. That I have been annexed here with this petition, my lord. Both the experience certificate and I-card also I have annexed here.
Heard, mister? Your name, please?
This is cover case, my lord.
Your
A.N.
name?
Ahmed. A.N. Ahmed.
A.N. Ahmed, learned counsel for the petitioner, and Mr. Musahari for the respondent in BTC. 4-2? 4-8. 4-8. Mr. Pujari, Bor Pujari? Respondent number 3. Respondent number 3. Who is for respondent number 1? State of Assam? Who is the standing counsel for forest department? D. Gogoi. D. Gogoi.
I will inform you, my.
Okay.
Yes.
Okay. Okay. In this petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent authorities to provide the benefit of minimum pay scale of casual laborers. Minimum pay scale to the petitioner. Pay scale of casual laborers to the petitioners who have been working from their date of engagement, that is 10/11/2006 and 1/5/2007 till date. The learned counsel for the petitioner submits that while dealing with similar issues in WPC number 5814 of 2024 and WPC number 4196 of 2025, a coordinate bench of this court by judgment and order dated 8/7/2017 and in writ appeal number 2017 has granted minimum scale of pay to the petitioners of the aforementioned petition, and the said decisions were upheld in writ appeal number 45 of 2014. And the present case of the petitioners are also squarely covered by the aforesaid decision, and as such, similar relief may be granted to the petitioners in the present petition. Mr. Musari, learned counsel for the petitioner, however, submits that he may be granted some time to obtain instruction. Bail is accordingly allowed. Rest shall list the matter in the first week of January. And in the meantime, Mr. Musari shall also examine the decision in WPC number 5814 of 2024 and 4196 of 2025 as to whether the case of the present petitioners are covered by the aforementioned decision or not, and to apprise this court on next day. Place the matter on.
Online.
Right.
Item number 26.
May I please, Your Lordship? Lordship, the matter pertains to appointment of graduate teacher science under the secondary education department. Lord, the issue here is that though the petitioner has secured marks more than the cutoff marks, even then he is not been selected. So, my lord, first Lordship may peruse the advertisement at page 26, my lord. So this advertisement is for filling up of 205 vacant post. My lord, got it? So the district-wise, subject-wise, medium-wise, and category-wise post details, as well as date and time of receipt of online applications for TET-cum recruitment test. It's a TET-cum recruitment test, my lord. The conditions of recruitments are there. Thereafter, at page 28, my lord may kindly have a look at the criteria for selection of graduate teacher.
So where is the document to show that you have secured more marks than the cutoff mark?
Yes, my lord, in the last page, my lord, at page 50, that is the list of cutoff marks, my lord. There are two issues basically, my lord. Let me clear with the issues, my lord. Because first thing is that he has selected the MIL as a Bengali medium school, my lord. If it is Bengali medium, then if your lordship have a look at the graduate teacher science in the column 3, my lord, in the cutoff marks list, my lord, last page 50, my lord. So that is regarding Bengali medium under unreserved category, this cutoff mark is 69.50, my lord. And under the PWD category, it is 24.25. Next, they have wrongly put the medium as Hindi, my lord. Even then also, under Hindi medium in PW category, he has secured more than the cutoff marks. It is graduate teacher science in column 3 at serial number 5, PWD category 70.25. That is his marks, my lord. He has secured that mark, my lord. And
In which
if your
column?
lordship will look at the mark sheet, my lord.
In which column?
My lord, in the PWD category, column 3, graduate teacher science, and the left side, my lord.
Yes.
Serial number 5, Hindi, my lord.
70.25.
Yes, 70.25. Under PW category, he has secured that mark, my lord. 70.25. His mark sheet is, my lord, will please to find at page 37. page 37 is mark sheet, my lord. Mark statement. Graduate teacher science, graduate teacher mathematics. Mark statement, marks awarded, written test 70.25, total marks 17.25. So he has secured more than the cutoff marks even in unreserved category, and even he is considered in the Hindi medium in PWD category, then also he has secured more than the cutoff marks. So even then, his candidature has been rejected, my lord. And on what ground they have been rejected? He has been rejected. There is no mention.
Mr. Dutta,
Let's not go. I'll take the instruction and file affidavit.
One post may be kept vacant, my lord. Otherwise, he will be highly prejudiced, my lord.
But already Lordship appointment has been made on 13th of November 2020. He has come down now.
Appointment has not been made on, my lord. Appointment notification has been issued.
Appointment letter has been distributed ceremoniously by the Chief Minister in the
And if your lordship have a look at page 29, the vacancy category, my lord,
you see, if the process is already completed, what purpose will be served?
my lord, if your
Now the
lordship have a
question
look
will
at page
whether-
20, my
No,
lord,
no.
if lordship
No,
have a,
no.
yes, my lord, I understand that. The merit list,
No, you listen me.
yes, my lord,
If the process is already completed,
my lord,
then what purpose will be served by filing this present petition?
my lord, he has,
And how can this court order for reserving one post for you
yes, my
if
lord.
the process is already completed?
That's what I'm going to convince your lordship at page 29, my lord.
Yes.
Page 29, my lord, E. That was the criteria for selection, my lord. E, the number of qualified candidates in the TET cum recruitment test shall be in the ratio of 1:1 of the vacancies advertised. It was 1:1 vacancies. My lord, his post is already in vacant position, my lord. It was not filled up because he has been selected, my lord, in the TET cum recruitment process. So that post may be kept vacant, my lord. That is my humble submission.
Yes.
I could not understand the submission. If he has not selected, has approached before his court for his selection, how that post is.
He is not understanding. That doesn't mean that there is no process.
Lordship, I am getting the matter to that give a concrete instruction to have in the court, Lordship. Not that he's to plotting his claim. His claim, Lordship, he was not selected under PWD category, though his mark is higher than the last cutoff mark, Lordship. So far as the limited understanding, I have understood like up to that position, Lordship. In this respect, Lordship, selecting a candidate under PWD category, there are many criteria regarding the calling of the category in the benchmark. What are the other candidates also that have to be checked? It is not at this stage, Lordship. If Lordship is to notice, I can come with the affidavit with details, Lordship. And there are the another provision, the verification of PWD status of the candidate at the time of appointment also. If the certificate, suppose he has annexed the certificate of 40%, if at the verification, he is found to have below that 40%, he is not entitled. There are many aspects may be come up. So Lordship may issue notice. But without Lordship regarding at this stage, because already selection for the.
Even my lord, keeping aside the PW category, he would be selected, my lord, in the unreserved category itself, under the Bengali medium.
No, first they will satisfy this court that any posts are existed
Yes, my lord.
after completion of the process.
This criteria, specifically speaking, that the vacancies was 1:1, my lord, and he has been selected because if your lordship had a look at my mark sheet, my lord, at annexed at page 37, again, my lord. My lord, I'm going further, my lord, at page 40. That was the provisional result, my lord. Provisional result of TET cum recruitment examination 2024 of graduate teachers under Government of Assam. That was his candidature, so and so. Devbang, yes, result qualified for appointment to the post of graduate teacher, science, subject to satisfactory medical examination. So he was qualified for appointment to the post. So his post was already reserved, my lord. No person was there against this post. Because the ratio was for qualification under the TET-CAM recruitment process, it was 1:1 as per the
Okay,
advertisement.
let him obtain instruction whether any post is lying vacant or not.
My lord,
Heard Mr. B.M. Decker, learned counsel for the petitioner. Mr. Dotto, learned standing counsel for the respondent in Secondary Education Department. In this petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction. The petitioner has right for setting aside and causing the impugned select list dated 3/12/2025 insofar as it concerned to the appointment of candidate for the post of graduate teachers within bracket science under the PWD category, and also to issue direction to the respondent authority to quash and set aside the select list published insofar as it concerned to the appointment of candidates for the post of graduate teacher science under the Bengali medium. And also to direct the respondent authorities to publish a fresh list for the advertised post of graduate teacher science under the PWD category, and to include the name of the petitioner and others on merit. And also to issue direction to the respondent authorities to appoint the petitioner as graduate teacher science against the post of graduate teacher science as advertised by the advertisement dated 26/12/2023. Mr. Decker, learned counsel for the petitioner, drawing the attention of this court to the final cutoff mark of TCR-2024, submits that the petitioner the cutoff mark in Bengali medium of graduate teacher science for unreserved category is 59.50 and for PWD category is 24.25 and for Hindi PWD category 70.25, and thereafter drawing the attention of this court to the page number 37 of the petition. Mr. Decker submits that the petitioner has obtained 70.25 marks, 25 marks as graduate teacher science and graduate teacher mathematics. But despite securing the marks more than the cutoff mark fixed in the Annexure 12 at page number 50 of the petition, the candidature of the petitioner was rejected by the respondent authorities, and being aggrieved, the petitioner approached this court by filing the present petition. Mr. Decker further submits that till disposal of the petition, a post may be kept reserved for the petitioner. However, Mr. Dotto, learned counsel for the respondent authority, submits that the selection process has already over and appointment letters have already been issued to the candidates. And as such, he submits that a discharge notice may be issued so that he may file his affidavit in opposition, bringing on record all the relevant facts. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that a late notice be issued to the respondent, returnable on the first week of January.
my lord,
8th of January.
there may be an observation, my lord, for considering the interim on the next date, my lord.
In the
After
meantime,
receiving-
Mr. Das learned, Mr. Dotto, learned standing counsel for the respondent authorities shall file his affidavit in opposition and also obtain instruction as to whether any post of graduate teacher science in Bengali and Hindi and PWD category are lying vacant or not. Interim pair of the petitioner will be considered on next list accordingly.
Much obliged, my lord.
Items for admission, item number 4, farmer matter.
May I please, the Lordship, my lord? Lordship, as per the order dated, my lord, 20th of November, my lord, 2025, my lord, I filed one additional affidavit, my lord. My lord will kindly go to, my lord, running page 100 and, my lord, 16, my lord. I'm sorry, 18, my lord, of my additional affidavit, my lord. And it starts from para 3, my lord, the operative portion, my lord. 119, my lord, page. If I may read, my lord, two small paragraphs, my lord. Paragraph number 3 and 4, my lord. Everything shall be very clear, my lord. Running page number 119, para number 3, my lord. May I read, my lord? Para number 4 is also relevant, my lord.
Now you don't have the dias data for the since the year 2010.
10 years, my lord. And there was a communication.
Now, how can you justify that there was enrollment for that period in your school?
Yes, my lord. For that, my lord, I will take your lordship to, my lord, the inspection report dated 5/5/2017, my lord, of my writ petition, my lord. Page 84, annexure 18, my lord. Kindly come to page 84, my lord. There was sufficient number of students in my school, my lord. Page 84 of the writ petition, annexure 18, my lord. This is an inspection report, my lord, which was carried out on 5th of May, my lord, 2017, my lord, by one of the authorities, my lord, SIF schools, my lord. Nagaon, my lord, Batodra, Nagaon. And In this particular inspection report, my lord, the number of students altogether in my school was found to be, my lord, 160, my lord, in total, my lord. And this report was never disputed by any of the official, my lord, respondents, my lord. And because of the, my lord, the earlier, my lord, Dias code, my lord, because of the dispute, this
No, this inspection report is of dated 5/5/2017.
17, my lord. It says, my lord, and for the year 2016 and 17, they found no enrollment in my school since the Dias code was blocked and it was not released, my lord. And because of the earlier dispute between the two schools, my lord, having same name and style, my lord. This is the only reason, my lord, they have not issued any, my lord, Dias code, my lord. And the reason, my lord, in their affidavit, if your lordship kindly turn to, my lord, running page, my lord, 151, my lord. This is very shocking, my lord. They said, my lord, by virtue of speaking order, by virtue of the finding of this honorable court, my lord, my school was found to be the genuine school, my lord. Even then, my lord, page 151, my lord, they said the school, my lord, of the earlier, my lord, private respondent, my lord, Hoibur Rahman, his school, my lord, this school is not in existence even, my lord. In the year 2016, they found no enrollment in the school, my lord. This is not my school, my lord. This is their school, my lord, which is not in existence, my lord, since 2014 and 15, my lord. Because, my lord, by virtue of earlier disposal order of this honorable court, my lord, the chairman of the district scrutiny committee, he was directed to pass a speaking order. Accordingly, the ADC education, he was, my lord, authorized to pass a speaking order. And accordingly, my lord, all the necessary testimonials from both the schools, my lord, were, my lord, submitted before the concerned authorities, my lord, ADC education. And on the findings of the, my lord, ADC, it was found that my school is the original school, my lord. And page 151 says that the school of the other party, my lord, the fake school, my lord. They have said that, my lord, there is no enrollment in the school in the year 2016 and 17. Whereas, my lord, this school is not in existence, my lord, since long back. This is not my school, my lord. Lord, she was asking for the, my lord, for producing of the report as regards my school, my lord. And the report that they have produced, my lord, is regarding that school, my lord, which is not in existence, my lord. And the inspection reports is always, my lord, in my favor, my lord. This was never disputed in any of the, my lord, affidavit filed by the, my lord, department. This page, my lord, 84, my lord.
No, this inspection report is of dated 5/5/2017.
17, my lord, 17.
But how this report will help you regarding enrollment of the students in the year 2010 till 2016 and 17?
My lord, regarding that part, my lord, there was no other inspection, my lord. They cannot say that there was no enrollment in the school, my lord. Since because in between, my lord,
You are the petitioner, it is your duty to establish that during that period some students were enrolled in your school.
yes.
Where is that document?
My lord, that document, my lord, I annexed, my lord, so far as, my lord, pertaining to the year 2017 is there, my lord.
No,
It is
in
regarding the
in
current
the
year.
earlier years. Since 2009, 10, 10, 11, 11, 12 till 2017.
Yes, my lord.
Where is the document?
The document is that, my lord, since it was blocked, my lord. Since the year 2010, the Dias code was
No,
blocked.
maybe it is
Well,
not
as
in
such, my
the
lord,
not
we
in the
submitted-
Dias code, but do you have any other document to show it?
My lord, right now, we don't have the any other inspection report since it was never
May
carried
not
out.
be, but do you have the school register?
We have the
Have you
school register.
enclosed the same with this petition to substantiate that you have enrollment in those years?
Yes. We have not annexed, my lord, but the inspection report, my lord, pertaining to the year 2017, my lord, it says that there were sufficient number of students in the school, my lord. It is just the, my lord, next year, my lord. They said in the year 2016, our school did not have, my lord, any, my lord, sufficient number of students, my lord. But in the next year, my
Yes,
lord,
that is the statutory requirement.
that is the requirement, but my lord, for release of the Dias
But
code, my lord.
you have no document to show that during that period there was enrollment in your school.
My lord, if my lord grants me another opportunity, I will be allowed to produce, my lord. I can produce, my lord, the number of the teachers attendance
No,
paid,
first
the
you tell
students.
me what is the requirement for provincialization?
Requirement is that, my lord, there has to be.
Your name should be reflected in the Dias data for the
Dias
third
data, my
9
lord.
and
This is the
10.
first requirement.
Any other requirement?
Lordship, the main, first of all, my lord, if Lordship sees the definition of Dias code, that's 2I. There, my lord, it is categorically stated that the district information system for education code prepared by the SSA as and as available in the records of the National University of Planning and Administration, New Delhi, that's NUPA. So the SSA prepares it, my lord, and sends it to the NUPA Dias. So, my lord, NUPA maintains, if in that NUPA Dias, their school name is not there, that means it's a.
Oh, how many years the Dias data is
So,
required?
my lord, will, let him complete his arguments, my lord.
No, you tell me,
My lord.
for how many years the Dias data is required?
My lord, otherwise, my lord, as per this thing, my lord, 2009-10, that as it is required, my lord, to show, my lord. Whereas as per the report which we have given, there are two reports. The first one, the affidavit which I have filed, which is at, on the 9th of September 25. If, as per that affidavit, my lord, as per the direction of the Honorable Court dated 7/11/23, we conducted inspection, my lord, in that particular school. As per that inspection, we have given the report, my lord, wherein the pictures also have been given, as well as the report has been given on oath, my lord, in the. as
No,
section one.
for how many years the name of the petitioner has to be reflected in the Dias data?
My lord,
After,
just for the year 2009 and 10, my lord. There's a provision, my lord, page 107, my lord, provision ZB, my lord, ZB, my lord. Of this book, my lord, 107, my lord.
Don't you- Every year they have to renew it. That's what the SSA is saying, my lord, the.
My lord,
Every year. they have
just
to renew
a
it, my
minute.
lord. And my lord, for provincialization, 2009 and 10, my lord, the enrollment.
It clearly says, my lord, the data, Dias data, my lord, pertaining to the year 2009 has to be there, my lord. It's a mandatory criteria, my lord. And so far as, my lord, our school is concerned, my lord, since there was a dispute, my lord, for which this Dias data was blocked, my lord.
So,
And in this regard, my lord, not only my own declaration, but from the official authority, my lord, the district officer, my lord, and the district mission coordinator, he had also made a communication, my lord.
Mr. Hamad, you first show me.
Definition 2ZB.
No,
There's
that-
given them.
I have
That's
record.
all right. I am asking you, what is the requirement for provincialization of the school and the service of the
Both.
petition?
One is provided the Dias code shall have to be issued on or before 2009-10, and Dias code issued thereafter shall not be considered for purpose of professional service of any employer or institution after 2019. So he has to have a Dias code maintained as per rule, as per section 270.
So in
And
the,
also may not read with 2I.
no, in the case of the school of the petitioner, there was Dias code for the year 2009 and 10.
Yes,
As
yes.
per, my lord, as per the report, my lord, as per the latest
Yes.
affidavit which I have filed, the additional affidavit which I have filed two affidavits. The latest affidavit which we have filed, which we have got from the executive director, SSA has written in the, my lord, Lordship kindly comes to page 144 of the additional affidavit which I have filed on 9th of December 25, which is the latest. This has been written.
Page number?
Page number 144. This is the letterhead of the Samaksa director. Here, my lord. Page 144.
Yes.
My lord, will kindly see it is a letter, it will be director elementary from the executive director SSA. It's referring to the reference of the reflect by the claim of the teacher school for provincialization of service of the teachers against Dr. Kodumani Patel LP School as per Provincialization Service Act was rejected. It is mentioned in the said order that on the basis of one report regarding enrollment in the school petitioner during the year 16-17, the claim of the petitioner for provincialization of service was rejected. As per report stated to have been submitted by the SSA, no enrollment of Dias database maintained by the NUPA for the year 16-17 of the district, the SNC as terminated in the order passed by the under reference. The order under reference was issued by the please direct the SSA to produce the report for the report 14/11/25. That is the report which I annexed in the previous affidavit. However, no such report is found on record available on the SSA. In view of the above, we are requested to produce the said report before the honorable authority. We have produced it in the previous report. Copy of the said report.
My lord, the question is, my lord,
So, my lord,
why- just a minute, let me finish my version.
I have not finished.
My lord, the question is, my lord,
Yes.
This is the affidavit subsequently filed, the doctor process that the report give us the thing that SSA has found that they are not there. So this is the report sir, which they have given. And second, my lord, is will actually come to page before that come to the affidavit which we have filed, my lord, on 9th of September, sir. Page 109, page 100. This is my lord the inspection report, which was subsequent to their report, sir. This is whatever they have given in the petition. This is the report which has been page 109, extra one. This is by the order of the honorable court. The lordship sees inspection report in connection with our WCC 3521/2022 Azizul Haq versus Haq. With reference to Samsara, I am directed to state that pursuant of the school 22, Rajasthan along with Jodhpur have conducted spot inspection of Dakshin Kadamani Pathar The Honorable High Court has passed an order dated 7/11/23, the judicial order, in connection with 352/22, wherein it is directed the authority to conduct inquiry relating to claim of the petitioner from Kuchilai. Accordingly, the inquiry of Dakshin Kadamani Pathar VLP school was carried out on 21/9/24, 10 a.m. In spot inquiry of the school, it is found that the said school is a kaccha house and the walls and pillars are made up of bamboo with a single roof. The basic needs of the school are not available in the school and there is no environment of learning for students. Furthermore, this is very important. Further, no teachers and students were found present in the school during the class hour at the time of the spot inspection. Since there is no teachers and students attending the school at the time of the spot inspection, the proceedings, books, and other documents relating to the enrollment of the school would not be verified. The condition of the school has been captured in the photo as that report was given in the photo was given on the last. It was in a very dilapidated front. There in the file. So my lord, after this report was given, he was saying that this report they were not there. They have given a reply to this also, saying that they somebody was the headmaster was unwell, my lord, and coincidentally, my lord, on the last of his submission, my lord, at that point of time, my lord, either has been my lord, the inspection was conducted, no one was present in the school, there was no teacher, no student, my lord. They should have been there, my lord, if it is a school technically running. So, my lord, in view of that, subsequently they have filed the additional affidavit, bringing on record the letter of the SSA. So, my lord, looking at both these aspects and tallying both these reports, it's clear, my lord, that my lord, this my lord, faithful. An appropriate order should follow.
May I clarify, my lord, now?
SSA can
Please take your
Yes.
seat.
Yes.
My lord, so far as my lord, the inspection report is concerned, my lord, I submitted my affidavit in reply, my lord. My lord will kindly have a look at page 110, my lord, running page, my lord, of my affidavit in reply. There I, my lord, clearly stated that on the day of inspection and regarding the inspection, my lord, there was no prior notice to us, my lord. We were kept totally ignorant, my lord. This is against the, my lord, rule of natural justice, my lord. And my lord, on the day of inspection,
How the rule of natural justice is applicable here?
at least we have the right to get the information, my lord, that the inspection will be carried out in our school, my lord. And on the,
But
my
on
lord,
that day, it
unfortunately, my
was
lord,
a school opening day.
no, my lord. And regarding, my lord, the
No,
inspection,
no, you tell me,
yes, my lord.
how your right to natural justice has been violated there?
My lord,
Because it was a
suddenly they
working day.
came, my lord, on a specific date and they had conducted an
It was a
inquiry.
working day.
And on the day, my
You were
lord,
supposed to remain
yes,
present
I
in the
admitted
school.
another fact, my lord, also, my lord, that on the day of inspection, my lord, there was some compulsion, my lord, that one of the close relative of both the, my lord, petitioners, my lord, he had succumbed,
So
my lord, for
therefore, both of you left the school.
my lord, we had to leave the school, my lord. That I admitted, my lord, on several occasions also. And page 117, my lord, this is the photograph of the school, my lord. The photograph that they have, my lord, annexed to the affidavit, my lord. Kindly have a look at page 117 of my affidavit in reply, my lord. This is the complete photograph of the school, my lord. Front side, my lord.
Okay.
School seems to be, my lord, having in proper condition,
No,
my lord.
uh,
So it is Kacha house, my lord. And the right now the present issue is that, my lord, whether I submitted, my lord, any application before the concerned authorities for release of my dias court continuously or not, my lord. And by virtue of my affidavit in, my lord, additional affidavit, latest one, my lord, page 100 and my lord. I'll take your lordship to my lord again, my lord. Page 116, my lord, of my affidavit, my lord. I submitted, my lord, consecutively, my lord, every year, my lord. Right from page 126, my lord, onward, my lord. Every year I submitted, my lord, application before the concerned authorities for release of the diaspora, my lord, of my school, my lord. Annexure B.
No,
page-
no, first tell me, as
Yes.
per the Act of Assam Education, Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017,
Yes, my lord.
what are the requirement for provincialization of service of a teacher in the school?
My lord, the requirement is that, my lord, the basic criteria is, my lord, there has to be a diascode
Hmm,
on or right from the year 2009 or 10, my lord.
hmm,
From the year 2009 10 or before, my lord.
hmm.
And there has to be sufficient number of students in the school, my lord.
Is that the only requirement?
The land and building has to be there and the proper infrastructure has to be there also, my lord. Page 108, my lord, of the book, my lord, this book. Section 3, my lord, says about the eligibility criteria, my lord.
Yes.
Yes. The school has to be established, my lord. The basic criteria is that on or before 1/1/2006, my lord.
Hmm.
This is one of the criteria. My lord. The second one is, my lord, there has to be land building and other infrastructure of such institution, my lord.
Hmm.
The third one is the school must have land in. The fourth one is the school has a minimum total enrollment of 30 students, my lord.
Hmm.
If it is a venture school, my lord, primary school. We all, my lord, we fulfill all the criteria, my lord.
Hmm.
Seven, except the, my lord, diaspora, my lord, which was not released, my lord. Although it was, my school was found to be, my lord, genuine school, my lord. These are some of the criteria, my lord. Why the diascode, my lord, was not released, my lord? Lordship will get the answer, my lord, if your lordship kindly turn to page 96 for a moment, my lord. Annexure 23 of the writ petition, my lord. How it was blocked? There was a request, a letter of request from the, my lord, concerned mission director, my lord. District mission coordinator, my lord. I'm sorry, my lord. Nogam, my lord. He had made a request, my lord, to the concerned, my lord, mission director, my lord, for release of the diascode, my lord, or to issue a fresh, my lord, in favor of our school, my lord. Page 23, my lord. This was dated in the year 2017, my lord. This communication was made, my lord. Page 96, annexure 23 for a moment, my lord.
No, Mr. Hamad, you have already shown those documents to me on earlier occasions.
Yes, my lord. Had it not been blocked, my lord, there would not have been any problem, my lord. Since the diascode was blocked, for which, my lord, in the new PA, my lord, no, my lord, enrollment was shown, my lord. Right from there 2010, my lord. Had it been released in our favor, my lord, since our school was found to be, my lord, genuine school, my lord, it would have been, my lord, definitely have been, my lord, continued in, my lord, new PA of, my lord, right from there 2010, my lord. And since the issue was decided in the year 2014 and 15, my lord, for which, my lord, right from the year 2010, the diascode in our favor, my lord, would not have been continued in new PA, my lord. This is the only reason, my lord, for which I am suffering, my lord. This issue was settled, my lord, in the year 2015, my lord. And in between this 2010 to 15, my lord, we could not fill up the gap, my lord. This was because of the, my lord, authorities, my lord. They did not consider our prayer, my lord. And thereafter, when we approached before this honorable court, my lord, then only we got justice, my lord. our school was declared to be my lord original school, my lord.
So, Mr. Fukon, there is no doubt that the school has DIAS code
My lord.
for the year 2009 and 10. That is there.
And that is the most crucial thing, my lord, because as per the act of, my lord, two ZB of the, my lord, Assam Education Provincialization of Service of Teachers and Reorganization of Education Restrictions Act, my lord, 17. Not there, my lord, venture lower primary school or venture LP school means the school imparting education up to class 5 established by people. So we can see prior to 1126 whose name figure in the diet school up to 2009, 2010. And prior to that, and whereof the service of the teachers have not been provisionalized under any act enacted by the state legislature. Provided that the diet code shall have to be issued on or before 2009 to 2010, which they have failed to show. Which they have failed to show. 2009, 2010 diets, they have failed to show. And my lord, as per the report of, as per the letter of the SSA also, my lord, they have said that they have no records from. And the other SSA is the main authority who basically maintains this diet school. And my lord, apart from that, my lord, to satisfy your lordship, my lord, the honorable court on my lord, as per the affidavit which I have, my lord, at page 109. My lord, there also, my lord, an inspection was made, my lord. That was, he was aware of that thing, there was an inspection to be conducted, my lord. Now, obviously, my lord, that inspection will be conducted, my lord, he's been informed that there will be an inspection which will be conducted. And the main thing which here it has to be seen is that the team which went to inspect, my lord, they went during the working hours, my lord. They have not gone, my lord, during any other hours. And in the working hours, my lord, and even if there is something, my lord, some, my lord, unfortunate incident takes place with a teacher, my lord, there has to be substitute teachers, my lord, who basically handle the school. They cannot just, my lord, shut it down and just go away. But even if they go, my lord, they have to inform their superior authorities. Have they made an application, my lord? Is there any application, my lord? Before the superior authorities, as far as we are concerned, my lord, we have not got anything from the concerned school, my lord, because my lord, the teachers have to be responsible. Looking at all these aspects, my lord, and also the report which is a judicial order where judicial, my lord, inspection was asked to be made by this thing, my lord. As per that, my lord, they also found that school was not functioning. So I may not leave it to your lordship, looking at all these aspects.
My lord, the only procedural lapse is that, my lord, on the day of inspection, my lord, nobody was there in the school. That I admitted, my lord, on many occasions, my lord. Save and accept, my lord, that part, my lord. I follow, my lord, and I fulfill all the criteria, my lord. Had we been present, my lord, in the school, my lord, on the day of inspection, my lord, this situation would not have arisen, my lord. And we had admitted, my lord, on many occasions, my lord. Even before filing of the, my lord, this affidavits, my lord.
No, there was another requirement that the name of the teacher shall be reflected continuously for 6 years from the year 2009 to 9-10 till 2000. Where is it is provided? Where it is provided? Which clause? 2Z?
Just now, but we kindly go to the definition, my lord.
Yes.
2ZB. With the venture lower primary school. 2ZB. Page 107. Venture lower primary school or venture LP school means the school imparting education up to class 5 and established by the people of the locality. My lord, this is important. Prior to 1/1/2006, my lord, here again, whose name figure in the dias code up to 2009. That means from 6 to 2006. From 1/1/2006 to up to 2009, 2010. And prior to that, and whereof the services of the teachers have not been provincialized under any act enacted by the state so far. Provided that the dias code shall have to be issued on or before. It has to be on or before 2009, 2010. Dias code issued thereafter shall not be considered for the purpose of provincialization of services of any employer. This is crucial. This 2ZB. Apart from the 2ZB, my lord, the definition is given at 2I of the dias code. Dias code maintained by it has to be in the NUPA. NUPA dias is the name, which is my lord, the SSA is the authority who basically looks after the rest. And they apply to the SSA. Faculty. 2I and 2ZB are the my lord, crucial, my lord,
Okay.
And apart from that, there is an inspection.
Mr. Hamad, you file an additional affidavit bringing on record the enrollment since the year 2009-10.
Enrollment position of the school.
Yes, yes, till this inspection report was filed on when this inspection report.
5/5/2017, my lord. Since there's an
17.
inspection report, my lord, that is why, my lord, we did not annex, my lord, any other further document, my lord. If
Okay,
your lordship
you-
permit me, I can produce, my lord.
Okay,
the number of
produce.
Yes, my lord.
Heard Mr. Hamad, learned counsel for the petitioner, and heard Mr. Hukam, learned standing counsel for the respondent in elementary education department, and Mr. Soudhury for respondent number.
For 3 and 4, 5,
3 and 4.
3 and 5 lots.
3 and 5. After hearing learned counsel for both the parties, it is provided that the petitioner shall file an additional affidavit bringing on record the enrollment position of the school since the year 2009-10 till 2017. Inspection report is at page number
My lord, 109.
109. No, another report was there.
The first additional affidavit is the one is filed on 9 September, that is 109. That is the affidavit subsequent to the order of the court. And the
No, that's
second one, my lord, is the report which with the.
No, Mr. Hamad has pointed out another affidavit,
My lord,
another letter,
Page 144.
144.
That is the SSA, the letter to the element.
Okay, till 16-17, 2016-17. From 2009-10 towards 2016-17. First week of January.
Lord, can it be in the second week if possible, or just after Bihu vacation, if possible,
Okay.
my lord? Because this may take some time. my lord.
SSL list the matter on
27 January.
27th of January.
Deep level.
Item number 5, order paper.
Who is for elementary education department?
Only thing is that my lord petitioner is retired from the service on 31/12/2023. Till date, my lord, he has not a single penny, my lord. And they are taking time, my lord. And entitlement is already decided by this honorable court in earlier round of litigation.
So, Mr. Dotto, you furnish a copy of this letter to her
File that. File that.
and also to the counsel for the petitioner. Heard Mr. Alam, learned counsel for the petitioner, Mr. Dotto for the respondent in secondary education department, and Ms. Esmo, learned standing counsel for the respondent in elementary education department, and Ms. Sharma for respondent number 3. Respondent number 3. Mr. Dotto has produced one letter of the Deputy Secretary to the Governor of Assam dated 15/12/2025 and another letter dated 15/12/2025, and on the basis of the said letter, Mr. Dotto submits that though the file was moved to the ARTP and PG department to obtain their views, yet the department has returned the file. Said department has returned the file, raising certain queries as under within inverted comma Department of School Education within bracket secondary is advised to furnish all relevant documents as to how past service was counted on earlier occasion for further examination of the proposal. And that the answer to the aforesaid query is being awaited by the department. In view of above, it is provided that Mr. Dotto shall furnish a copy of the letter dated 15/12/2025, letters dated so and so to Ms. Kaur, learned standing counsel for the elementary education department, to obtain up to date status of the said letter and apprise this court immediately after reopening of the vacation. Recess shall list the matter on. The letter produced before the court today shall be marked as A and B and be tagged with the record.
6th January.
Plus me.
Item 7, order maker.
May it please your lordship. This matter is regarding the in charge principal of a higher secondary school, my lord. In last occasion, my lord, my learned friend has taken time as to whether, because in the similar facts and circumstances, the order has been recalled, the impugned order has been recalled, and it has been given to the petitioner in that. So that order I have also placed. That is
Okay.
before your lordship.
Yes, you received the instruction.
Affidavit, yeah.
The first point that we had taken, the petitioner is more than 7 years of age. In paragraph number 6.
No, you have filed affidavit, that's all right, but when the vacancy arose,
Yes, your lordship.
what was the age of the petitioner?
On that point, that's not given. However, if you go by the rules, see the rules. clerical. The age of the candidate must not be more than.
No, that is there, but the question is, that is to be considered on which date? That is the point.
Instruction we are not receiving.
And in fact, my lord will find, my lord, in their affidavit, my lord, page 16. Page 16, para 4, my lord. As well of
Page 60.
page 16, para 4, my lord, of their affidavit. The answering defendant beg to state that the upon the after retirement of the Bhubaneswar Soikia, principal on the in charge 13 or 36, yes, my lord, sorry.
Paragraph number? Paragraph number.
Para 4, my lord.
Okay. Yes.
So here my lord will find that the second para, retirement of Sri Bhubaneswar Soikia, principal in charge of Dokhinpad Higher Secondary School on 31st/8/23, my lord. So on that day, my lord, the retirement was taken place and post was fallen vacant. And then my lord will find the Inspector of Schools NDC Nagaon district submitted the seniority list of the teachers of the said school by letter dated, my lord, 21/8/23. So 21st of, my lord, August. This letter was submitted by the Inspector of Schools, my lord, to the director for along with the seniority list. And then my lord will find in the next para, my lord. Then on perusal of the seniority list, it is so and so document, the Inspector of Schools NDC was allowed to hold charge of the principal in charge, so and so, by order dated 3/10/23. So here my lord will find on the date of my lord retirement, he was in age, my lord. He was 6 years age. And that is the only point taken, my lord. And that point has been taken now, my lord, after 1 year, 1.5 years, my lord, because this repetition was filed in, my lord, 24. And 1 year, 6 months has gone by. Now they have filed this affidavit saying the age criteria, my lord. At the relevant point of time, he was aged, my lord. And so for the other part of is concerned, my lord, criteria is concerned, he is MA, BEd, and the 33 years service, senior most teachers, and that, my lord, will find, just I am relying on 3 documents, my lord, here, of their affidavit. Page 40, my lord.
Yes.
Page 40, this is the letter, my lord, issued by the Inspector of Schools, my lord, and that was issued on, my lord, 21/8, my lord, this letter. And this letter has been issued, and in this letter, my lord, will find that the earlier principal has retired on, my lord, 31/23. This is the letter issued by the Inspector of Schools, my lord, and it was addressed to the, my lord, director, my lord. And next page, my lord, will find, and it is also issued by the Inspector of Schools, my lord. That is 14, yes, 14/8, my lord. This was addressed to the Inspector of Schools by the principal, my lord, saying the seniority list. And the seniority list, my lord, will find next one. That is their document, my lord. Page 42, my lord. In 42, my lord, will find, my name is serial number 1, my lord. Serial number 1, my lord. And the third column, my lord, will find that date of birth, my lord, date of birth. So it is admittedly, my lord, he is having this, and he has fulfilled all the criteria to be the principal. And here, my lord, only in charge. And only thing is this, my lord, this man is going to be retired after, my lord, to now 58 years, my lord. At this stage, my lord, is the in charge principal and he was not given, and junior person was given. Then, my lord, there's a question of prestige also. Otherwise, I will not get so much other benefit, my lord. Only thing is this, my lord, I am the senior most person. It is admitted by them, my lord. I have fulfilled all the criteria, but it has not been given. The NEP order has been passed.
Okay. Okay. Yes, anything to say? Yes.
In my application.
Mm.
The petitioner had acquired MA degree from Guwahati University without obtaining.
It has been clarified, my lord.
Lordship, I just want to raise the fact that in other matters, your lordship, where your lordship decided that without an embassy, that will not invalidate your lordship. In those cases, they had all taken MA degree to distance module. Here, it is not for distance, it is regular module. That is the difference.
But anyway, this point has been clarified.
Issued so-called notice to the petitioner, your lordship, on 14/5/2025. And the order that my senior counselor placed your lordship in that order also, that person had obtained that degree from this through distance mode.
And in reply affidavit, my lord, I have given the order. The pattern of decisions are there by different bench of this honorable court, my lord, on this point, my lord. I have annexed one of the order, my lord, that my lord will find page 54 of the reply affidavit, my lord. And also I have produced one more order, my lord. Many orders are there, my lord.
Okay. Okay.
And there
Art,
everything has been
Mr. M.S.
discussed.
Chaudhary, learned senior counsel for the petition. Assisted by Mr.
SN Ahmed.
Learned counsel for the petitioner and Ms. De Musare, learned standing counsel for the respondent number 2.
Oniba.
Argument concluded, list the matter. No, judgment reserved.
Fine.
Numbers 8 and 9, Parliament Mayor.
Make please your lordship.
Yes.
My lord, I'm supplying the compiled copy of all the annexures as well as the regulations of both these two items. Lordship, it is covered by your lordship, 3 judgments of this honorable court, lordship. And my learned friend already filed his affidavit. I will not take much more time because I have given all the details and everything, lordship, in my.
Well, compilation copy has been furnished to me, where
Yes.
all the regulations of the regulatory authorities are there.
There.
If it goes to it, my lord, I can actually run my argument based on those also, but there may be some criteria where, my lord, the NOC, whether it's required or not, it may be reflected. So the
And-
entire issue is based on, my lord, whether the university can ask for an NOC from the petitioner institution for running the course or getting the affiliation. Because the courses are different. Earlier, my lord, regarding LLB, this honorable court has held it to initially. For BA, another judgment, and for BA integrated with BA and BSc. Same judgment was passed by the honorable court, and NOC is not necessary because the regulatory authority has not given any such criteria. So,
And-
huge bulk has been given to me to say.
Not today, lordship, today's earlier, lordship.
No,
And
ultimately, there was some time, my lord, let it be on the review. At least I can, my
First
lord,
week of January.
yes, I will advance my arguments.
8 and 9, both two
Both-
paper,
Okay, hold it.
Yes.
lordship.
Heard, Mr.
Let it be remain as part at lordship.
Okay, Mr. K.A.
K.
Majumdar, learned counsel for the petitioner. Mr. Majumdar has submitted.
Big bulky
written
was
note of
the
argument
item number 8, lordship, and
with
small one is the item number 9.
some of the decision of this
That
court
one, lordship, a big
and
one,
also of coordinate bench of this court and also the concerned act and rules. At this stage, Mr. Gogoi, learned standing counsel for the respondent authority, submits that he may be granted sometimes as the copy of the written argument as well as the compilation of judgment has been furnished to him today. Today or
No, Lordship, 2 days early, Lordship. I
2 days back, and he could not go through the same, and he placed
I had
placed the
supplied it
matter in the first week of
earlier.
January.
But
We are
only
allowed recess and lays the matter on.
short date maybe because student Lordship.
As parted.
Lordship, please. As part of Lordship.
My lord, on the last occasion, we are directed to obtain judgment regarding, my lord, unequal bargaining, my lord. I have obtained, my lord. 1986 3 SSC 156, my lord, page 216, my lord. Yes. My lord, 8th line below, my lord. May I read, my lord? Article 14 of the Constitution guarantees to all persons equality before the law and the equal protection of the laws. The principle deducible from the above discussions on this part of the case is in consonance with right and reason, intended to secure social and economic justice, and conforms to the mandate of the Great Equality Clause in Article 14. This principle is that the courts will not enforce and will, when called upon to do so, strike down an unfair and unreasonable contract or an unfair reasonable clause in a contract entered into between the parties who are not equal in bargaining power. It is difficult to give an exhaustive list of all bargains of this type. No court can visualize the different situations which can arise in the affairs of men. One can only attempt to give some illustrations. For instance, the above principle will apply where the inequality of the bargaining power is the result of the great disparity in the economic strength of the contracting parties. It will apply where the inequality is the result of circumstances, whether of the creation of the parties or not. It will apply to situations in which the weaker party is in a position in which he can obtain goods or services or means of livelihood only upon the terms imposed by the stronger party or go without them. It will also apply where a man has no choice, or rather no meaningful choice, but to give his assent to a contract or to sign on the dotted line in a prescribed or standard form, or to accept a set of rules as part of the contract. However, unfair, unreasonable, unconscionable a clause in that contract or form of rules may be. This principle, however, will not apply where the bargaining power of the contracting parties is equal or almost equal. This principle may not apply where the both parties are businessmen and the contract is a commercial transaction. In today's complex world of giant corporations with their vast infrastructural organization and with the state through its instrumentalities and agencies entering into almost every branch of industry and commerce, there can be myriad situations which results in unfair and unreasonable bargains between the parties possessing wholly disproportionate and unequal bargaining power. These cases can neither be enumerated nor fully illustrated. The court must judge each case on its own facts and circumstances. Heard Mr. D.K. Roy, learned counsel for the petitioner. Mr. Okon, learned standing counsel for the respondent in Elementary Education Department. And Mr. Musahari for the respondent number 3. Person to order dated 9/12/2025, Mr. Roy. Learned counsel for the petitioner has produced one decision of Honorable Supreme Court in support of his argument. Uh, Judgment reserved.
Obliged.
I think 11.
Wait, Your Lordship. In this case, my lord, I have filed an additional affidavit. Earlier, my lord, against the petition, they file a my lord, affidavit in opposition, whereby they, my lord, explain that due to interference of the Honorable Apex Court, the petitioners are not entitled to the revision. But I have annexed those documents whereby the government has decided to give the benefit of revision in my additional affidavit.
Lordship, we need to have instruction on this, Lordship, because this is recently filed, Lordship, only on 27th November.
So when the instruction will be available?
Lordship, it will require at least 2 weeks, Lordship.
In respect of the additional affidavit
Fine.
filed by the petitioner. Heard Mr. I.S. Soikia, learned counsel for the petitioner. And
I think Lordship Finance also needs to prepare for some enactments where the finance has been addressed, Lordship.
Right.
Some complex.
so here the additional subsecretary to the finance department is a party. Respondent number 4. Oh,
Two departments are concerned also. One is GDDS and one is finance department. Seen the immediately close. I've seen many documents from the finance also. So let us have the necessary instruction lots. Lots of will take this matter for the end of January. In the meantime, if you require lots, you will find a declare if required.
okay. The learned counsels for the respondent authority submits that. Since the petitioner has filed one additional affidavit, enclosing some of the documents, some of which are relates to the finance department. And as such, they are required to obtain instruction in this regard. And price for listing the matter towards the end of January. They are allowed necessarily is the matter. In the last week of January.
So fix a date, my lord. The date we fix them.
Okay.
30.
Obliged, my lord.
Item 13.
Your Honor, finally the matter be taken over for the time being, like the council is left in another courtroom.
Lordship, in this matter, Lordship.
Received one letter on 11 December, Lordship, the director SCRD. Here they are praying for some more time, Lordship, for preparation of the Panama, Lordship. So,
Okay. So you have not filed your affidavit till today?
that is why they are asking for some more time.
Okay. Heard Mr.
Ravi Agarwala.
Learned counsel for the petitioner. And also heard Mr. Nayok, learned standing counsel for the SCRT, being respondent number 3. Mr. Nayok submits that the department has asked for granting some more time to file the affidavit in opposition. And accordingly, he pressed for listing the matter in the last week of January. We are allowed to list the matter in the last week of January. In the meantime, the respondent authorities shall file their affidavit in opposition.
Obliged, Lord.
Obliged, Your Honor.
15.
May I please? This matter regarding compassionate appointment, my lord, recommended by the DLC, but it is pending before the SLC, my lord. So, my lord, this matter may be considered, my lord, by the SLC.
When the DLC has taken the decision,
My lord, DLC recommended, my lord, it is 2023, my lord.
23.
31/7/2023, my lord, page 22, my lord.
Whether you have approached this court earlier?
No, my lord.
This is lordship. Lordship may kindly parents take note of the date of death, lordship. It is 1999 lordship. Mother applied, her name was recommended. She didn't come to court. Later on, the son, he obtained majority. Then becoming major, he again applied. Now in 99, this one, in 2023, this has been recommended lordship, which is absolutely
now-
the set principle lordship.
No, that's all right. Now let it be placed before the SLC and let SLC take a decision in accordance with law.
Lordship, presently there is no SLC lordship. Because of the notification, lordship is, they were of 18th of September notification. 18 September 2024 notification lordship. Then there are number of cases lordship, which cases has already been lordship came to a conclusion lordship, and common order has been passed. Accordingly, lordship SOP has been issued. Applications were called for. So all these things are now pending with the government.
No, that's all right. Whether you have applied for person to the
Yes,
notice
sir, yes,
issued by the
Yes, sir, 30,
Take its own course lordship, if it is applied.
Yes.
If it's applied, lordship will have no objection because this will take its own course and it will be taken up in accordance with the law. lordship.
Yes.
Yes.
We are disposing of this petition.
Lordship.
Okay, next.
deeply obliged.
Yeah, that's good.
17.
In compliance of my lord's order, lordship. Yesterday, their account deposited 55.73 crores, lordship. And Baki remaining part is, lordship, after calculation and deduction, it will be paid shortly, lordship. All amounts are sanctioned by the government. There is a proposal for giving second installment 15 crores. Instead of 15 crores, the authority has given, lordship, 55.74 crores.
I have instructions, your lordship. Yesterday, at night, lordship, some of the petitioners have received certain amount, your lordship.
Yesterday.
Yesterday night.
All
That is the
amounts are-
second installment.
Second installment. Yes, final installment will be, lordship, some deduction part to final may kindly produce the instruction. Last paragraph is starts from father also.
Okay.
So Malon may posted it February 1st week or January last week, lordship. In the meantime, it will be cleared, lordship.
Okay.
So
Let
lordship
it
may
be
posted
at the
it
month of January, your lordship.
February 1st week, lordship may posted it. In the meantime, it will be cleared. In a short time, if we clear just the calculation part is.
Okay. Okay. Heard Mr. Das, learned counsel.
DJ
for the
Das, your lordship.
Petitioner, Mr. Gogoi. K. Gogoi, learned counsel for the contender, respondent contender number 1. Mr. Gogoi for B. Gogoi for Finance Department. Okay. And Mr. Goswami for respondent number 5. And Mr. Tobilder for respondent number
But sir, January,
Four.
February fixed kuri ase.
4.
January, February fixed kuri.
During the course of deliberation, Mr. Das learned counsel for the petitioner appraised this court that as per his instruction, the petitioners have received some of the amount. And Mr. Gogoi learned counsel for the respondent number 1 has produced one letter. This letter is of register. This department is of this is of Dibrugarh University.
Dibrugarh University written register or
So Soudry, you have received the instruction?
Yes, yes. Milord will keep the matter pending, Milord, let them make the payment. This is all official, we have not received anything.
Okay.
Let the matter come in the, after Bihu, Milord. In the
Okay.
meantime, let us see how things progress.
Okay. Then record his presence, senior counsel for the Mr. Gogoi learned counsel for the Dibrugarh. Mr. Gogoi, you are for Dibrugarh University. You are for government of Assam, state of Assam.
And Dibrugarh University also, my lord, make their position clear because now it appears the money has been released. So they should not take the stand that we have not received money. That's why, my lord, I am saying, my lord, lordship will keep the matter pending until the last installment. Maybe another 1 or 2 dates.
Mr. Gogoi has submitted that the amount of rupees 55.73 crore has been sanctioned.
It is already credited to the account of the petitioners.
Sanctioned, and the said amount has already been credited in the account of the petitioners. And the remaining amount will be paid within a short period of time after finalizing all the calculations such as mandatory deduction and recoverable. Mr. B. Gogoi, learned standing counsel for the finance department, has also produced on letter dated 11/12/2025 and he submits that the finance department has already sanctioned the entire amount. Entire amount.
It was the amount into 82.13 crores.
82.13 crores. And since a sum of rupees 55.73 crore has already been credited in the account of the petitioners, the rest of the amount will be credited very shortly. And taking note of the submission of learned counsel for both the parties, it is provided that recess shall raise the matter at the first week of February. First week of February.
Completed.
The letter produced before the court today shall be marked as Annexure X and Y and be tagged with the record.
Next to
Item 18, Lordship, may kindly take up this matter after some time, Lordship. Arguing counsel, Mr. Escalante is coming, Lordship.
let it go after vacation.
Okay.
First week, Milord, first week.
Okay. As agreed by learned advocates of both the parties.
It can come up on 7th, 5th, we are reopening. 7th? Okay, okay. Thank you.
Item 20.
Wait, please, my lords. My lords, my only prayer before my lords is to my lords may kindly fix a date in the month of January, my lords. Because my lords, it's been 7 months since the direction has been issued by this honorable court, my lords. He has not been allowed to join his services, my lords. It's been 7 months. My lords, may kindly peruse page number 38, paragraph 47, my lords. That is the direction issued by this honorable court.
So, Mr. Das, there is specific direction for allowing him to join. So why he was not allowed to join? No. No. This order was passed on
16/5/2025, my lords, 16th of May.
So almost
7 months.
7 months elapsed.
Yes, my lord.
You have not complied with the order. Hmm? So why he has not been allowed? Mr. Das?
I could take instruction, but kindly.
No, on Friday you obtained instruction. This order was passed on 8/9/2025. Since then, this 4 months elapsed. 3 months elapsed. You have failed to obtain instruction. Heard, Mr.
T. Das, my lord.
First week of January.
No. Learned counsel for the petitioner. And Mr. S. Das, learned counsel for the contemners. For all the contemners?
Because I have filed, for my lord, 2. What we have authorized for 3, my lord, and for 1, we have not received the.
Oh, 2 and 3.
For 1.
One is State of Assam,
Yes.
Secretary.
With the service council, not I haven't said, my lord. Respect to 1.
You track the this service of notice upon the respondent number 1. It was sent by speed post.
My lord, usual
You
course.
track the consignment.
Yes, my lord. If required, my lord, we'll take fresh steps on respondent on content number 1, my lords. But we have taken steps.
Mr. Das for respondent container number 2 and 3. The learned office note dated 28/11/2025 indicates that neither AD card nor unserved notice in respect of the respondent number 1 received back by the registry. The learned counsel for the petitioner submits that he will take fresh step upon respondent number 1. Respondent contemner number 1. However, the learned counsel for the petitioner is directed to track the consignment, then file a report, and produce the report before this court on Friday. In the meantime, Mr. Das, learned counsel for the contemner shall obtain necessary instruction as to why the petitioner has not been reinstated despite specific direction of this court by judgment and order dated 16/5/2025 in WPC number 3864 of 2017.
Published, my lord.
Item 22.
May I please, my lordship, service is completed, my lord.
Service complete.
Yes, my lord, as per office note. Matter may be fixed for admission hearing.
Admission hearing
I am appearing for the restaurant 4 and 5.
4 and 5. Okay. 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 Heard, Mr. A.R. Medhil, learned counsel for the petitioner. Mr. Your good name, please.
K Das.
A.
K Das.
K. Das, learned counsel for the respondent number
4 and 5.
4 and 5. Miss P. Odhikari for respondent number 8 and 9. And Miss Sharma for respondent number 1, 2, and 3. 1, 2, and 3. The learned counsel for the petitioner submits that service in this case has already been completed, and the matter may be listed for admission hearing. Accordingly, it is provided that registrar shall list the matter for admission hearing after 2 weeks or 4 weeks?
After 2 weeks.
After 2 weeks. In the meantime, the respondents shall file their affidavit in opposition.
My lord, my interim order. my lord.
Interim order passed earlier shall continue.
Awesome.
For hearing, item number 23, Parliament meeting.
Yes, Mr. Das,
Yes, my lord, lordships.
you have found anything?
In this matter, lordships wanted to have a satisfaction
Hmm.
whether the order passed by the educational tribunal
Hmm.
can be assailed before this court
Hmm.
under Article 226 or not, my lord.
Hmm.
My lord, I have got two judgments.
Hmm.
May I just place, my lord?
Hmm.
Because the ultimate question before us will be whether the tribunal is a court or not.
Hmm.
I have seen the judgments. In all the judgments, it has been held by the Honorable Apex Court that judicial order writ petition doesn't lie against the judicial order passed by the court,
Civil court.
civil court.
Hmm.
So it has to be, it can be filed under 227.
227.
Now-
But if alternative remedy is there, then you cannot.
Now the question that arises is that whether the educational tribunal, although it is, my lord,
Man by
a, my lord, honorable
Judicial
judge,
officer.
judicial officer,
Hmm.
whether the educational tribunal or any tribunal, as because it was manned by a judicial officer, can be construed to be a court.
Hmm.
That is the issue. My lord, if I just take your lordships to this 2015
Hmm.
5 SCC 423,
Hmm.
the relevant paragraphs would be 11, 18, 21, 25, and 27.
Hmm. So 27 is the ratio of the case.
Yes, my lord. 27 is the ratio of the case that judicial order of civil court are not amenable to writ of certiorari under Article 226.
Hmm.
So the order passed by the tribunal,
Hmm.
educational tribunal, cannot be construed to be a judicial order in the of a civil court, my lord, in my submission, and that has been held in the previous paragraphs.
Hmm.
11. Then I'll just place the relevant paragraphs, my lord.
Hmm.
Para 11, my lord, will kindly have a look.
Hmm.
It provides that the order of the judicial court stood on a different footing from the quasi judicial order of the authorities or tribunal.
Hmm.
Now, my lord will kindly take up the next judgment.
Hmm.
para 16, 17, 18 and 19. May I just read slowly, my lord? Although para 16, my lord. Although the term court has not been defined under the Act, it is indisputable that courts belong to the judicial hierarchy and constitute the country's judiciary as distinct from the executive or legislative branches of the state. Judicial functions involve the decision of the rights and liabilities of the parties. An inquiry and investigation into the facts is a material part of the judicial function. The legislature in its wisdom has created tribunals and transferred the work which was regularly done by the civil courts to them, as it was found necessary to do so in order to provide efficacious remedy and also to reduce the burden on the civil court, and further also to save the aggrieved person from bearing the burden of heavy court fees, etc. Thus, the system of tribunal was created as a machinery for the speedy disposal of the claims arising under a particular statute/act. Most of the tribunals have been given the power to lay down their own procedure. In some cases, the procedure may be adopted by the tribunal and the same may require approval of the competent authority through government. However, in each case, the principle of natural justice are required to be observed. Such tribunals therefore basically performs quasi-judicial functions. The system of tribunal is hence unlike that of the regularly constituted court under the hierarchy of judicial system, which are not authorized to devise their own procedure for dealing with cases. Under certain statutes, tribunals have been authorized to exercise certain powers conferred under some provisions of the Code of Civil Procedure or the Code of Criminal Procedure, but not under the whole code, be it civil or criminal. However, in a regular court, the state courts in their entirety, civil as well as criminal, must be strictly adhered to. Therefore, from the above, it is evident that the term court and the tribunal are not interchangeable. A tribunal, para 17, my lord, a tribunal may not necessarily be a court, in spite of the fact that it may be presided over by a judicial officer, as the other qualified person may also possibly be appointed to perform such duty. One of the tests to determine whether a tribunal is a court or not is to check whether the High Court has revisional jurisdiction so far as the judgment and order passed by the tribunal are concerned. The supervisory or revisional jurisdiction is considered to be a power vested in any superior court or tribunal, enabling it to satisfy itself as regards the correctness of the orders of the inferior tribunal. This is the basic difference between appellate and supervisory jurisdiction. The appellate jurisdictions confers a right upon the aggrieved person to complain in prescribed manner to a higher forum, whereas supervisory revisional power has a different object and purpose altogether, as it confers the right and responsibility upon the higher forum to keep the subordinate tribunals within its limits of the law. It is for this reason that revisional power can be exercised by the competent authority / court suo motu, in order to see that subordinate tribunals do not transgress the rules of law and are kept within the framework of the powers conferred upon them. Such revisional powers have to be exercised sparingly only as a decision in order to prevent gross injustice, and the same cannot be claimed as a matter of right by any party. Even if the person heading the tribunal is otherwise a judicial officer, my lord, this is important, he may merely be a persona designator but not a court, despite the fact that he is expected to act in a quasi-judicial manner. In a generic sense, a court is also a tribunal. However, courts are only such tribunals as has been created by the statute concerned and belong to the judicial department of a state as opposed to the executive branch of the said state. The expression court is understood in the context of its normally accepted connotation as an adjudicating body which performs judicial functions, rendering definite judgment, having a sense of finality and authoritativeness to bind the parties litigating before it. Secondly, it should be in the course of exercise of the sovereign judicial power transferred to it by the state. Any tribunal or authority, therefore, that possesses these attributes may be categorized as court. Tribunals have primarily been constituted to deal with the cases under special law and to hence provide a specialized adjudication alongside the courts. Therefore, a particular act / set of rules will determine
whether the functions of a particular tribunal are akin to those of the court, which provide for basic administration of justice, where there is a list between two contesting parties and a statutory authority is required to decide such dispute between them. Such an authority may be called as a quasi-judicial authority, i.e. a situation where a statutory authority is empowered under a statute to do any act. The order of such authority would adversely affect the subject. Although there is no list or two contending parties, and the contest is between the authority and the subject, and D, the statutory authority is required to act judicially under the statute. The decision of the said authority is a quasi-judicial decision. An authority may be described as a quasi-judicial authority when it possesses certain attributes or trappings of a court, but not all. In case certain powers under CPC or CRPC have been conferred upon an authority, but it has not been entrusted with the judicial power of the state, it cannot be held to be a court. Now, para 19, my lord. In Harinagar Sugar Mill Limited versus Sham Sundar Jhunjhunwala, Hidayatullah J made a distinction between a court and a tribunal, as it explained hereunder. These tribunals have the authority of law to pronounce upon valuable rights. They act in a judicial manner and even on evidence on oath, but they are not part of the ordinary courts of civil judicature. They share the exercise of the judicial power of the state, but they are brought into existence to implement some administrative policy or to determine controversies arising out of some administrative law. They are very similar to courts, but are not courts. When the Constitution speaks of courts in Article 136, 227, or 228, or in Article 233 to 237, or in lists, it contemplates court of civil judicature, but not tribunals and other than such courts. This is the reason for using both expressions in Article 136 and 227. By courts is meant courts of civil judicature, and by tribunals, those bodies of men who are appointed to decide controversies arising under certain special law. Amongst the power of the state is included the power to decide such controversies. This is undoubtedly one of the attributes of the state and is aptly called the judicial power of the state. In exercise of this power, a clear division is thus noticeable. Broadly speaking, certain special matters go before tribunals and the residue go before the ordinary courts of civil judicature. So in my humble submission, for court, the sovereign power of the state has to be there for being a court. The court has to exercise the sovereign power of the state. Here the tribunal was constituted pursuant to an OM initially, notification initially, and thereafter it was incorporated in the Act of 2017 in 19.2, section 19.2. So this tribunal, although manned by a judicial officer, my lord, cannot be construed to be a court. And in view of that, my lord, the order of the my lord, educational tribunal is assailable under Article 226, my lord. This is not, my lord, a court under 233, my lord, of the Constitution. This tribunal is a quasi-judicial body determining the list between the parties. So it's not a court in my humble submission. And that is the reason why, my lord, the writ petition under Article 226 would be maintainable.
Okay, now whether the matter is ready for hearing.
Lord, this matter can be taken up after the vacation. Today I wanted, Lord, I was required to satisfy your lordships with regard to this point only.
Heard Mr. S.K. Das, learned counsel for the petitioner. Mr. Chakraborty for respondent number 4. Respondent number 4. For respondent number 1, 2, and 3. You, Ms. Musari for respondent number 1, 2, and 3. Person to order dated 9/12/2025, Mr. Das has produced 2 decisions of Honorable Supreme Court, one in Radheshyam and another versus Sahabi Nath and others. reported in 2015 5 SSC 423, and also another decision of Supreme Court in the case of State of Gujarat and another versus Gujarat Revenue Tribunal, Bar Association and another reported in 2012 10 SSC 533, the 353. And on the basis of those decisions, Mr. Das submits that this court has jurisdiction to entertain this petition under Article 226 of the Constitution of India. The submission of Mr. Das needs further consideration. Let this case be listed on in the first week of January.
Fine,
In the first week of January. In the first week of January for final hearing.
Yes.
My lord, it's the date. I think it will be. What is communication?
First thing, yes.
Up to 28th January.
Fine, man.
Okay. Item 24.
One clarification, my lord. Even if otherwise, if we think also that it's a court, even if assuming, even then also the jurisdiction of this court, my lord, cannot be taken away. Even if it's a court, then also, my lord, 227 will come.
No, that's
Division
not
of
like
jurisdiction.
227 will come only then when there is no alternative remedy.
Yes. Yes, that's true. Yes. Highly appreciated.
Yeah, please. This is the last occasion, my lord, the instruction was called for whether vacancy is available or not, my lord. I placed one, your worship, 2,900 vacancies available, my lord, in the elementary government, my lord. In January, my lord, this advertisement was issued, my lord, and process is not completed till date. This is the first advertisement, man. Just started document verification against this advertisement.
The process has been completed by now.
By now, it has been completed with them. Earlier process is complete now. Now there are vacancies, clause 3, you will find. Fresh process will start, fresh advertisement will be issued. The petition of partnership and lordship.
Pardon?
Clause 3 is there. So fresh process will program vacancies position. However, there are vacancies of teachers to maintain PTR currently under the jurisdiction of the director, and advertisement will be published subsequently to fill up the vacancies as per approval of the government.
This advertisement is just
The petitioner will participate in the process, like upcoming recruitment process, and if he is eligible.
No, that's all right. But you have not uploaded your original mark sheets.
Lordship, at the time of my lord, original and my lord, betterment, both are same, my lord. Subject are same, my lord. At the time of my lord, submission of online application, my lord, I submitted 2 betterment certificate, my lord, and they
No, why
considered
not
my
the original mark sheet?
original mark sheet, my lord. I have not annexed, my lord.
Pardon?
Admittedly, the petitioner has not uploaded the marks.
It is admitted, my lord. I have not.
Then how can you?
Worship, after that, my lord, the document was verified, my lord, the physical, in physical verification, my lord, I appeared before the authority, and my certificate and all documents are verified, my lord.
No. What was the condition in the advertisement? You have to upload it at the
Yes.
time of filing your application.
Yes, my lord.
But you have not complied with the same.
Lordship, my rejection was not that, my lord,
No, you say, you furnish a copy to him
Yes, ma'am.
so that he may obtain
Lordship,
instruction.
their affidavit may be seen, my lord.
No, no,
They are content-
he has produced his instruction today. You go through the same.
Yes,
You come with your instruction. Heard Mr. Loskor, learned counsel for the petitioner. Mr. P.N. Sharma, learned standing counsel for the elementary education department. Mr. Sharma, during the course of hearing, has produced one letter dated 16/12/2025, issued by the Director, Secondary Education. And on the basis of the same, Mr. Sharma submits that the petitioner had never uploaded his original mark sheet and therefore he marks have been calculated based only on the betterment mark sheet containing all 5 subjects. All 5 subjects. A copy of the aforesaid instruction be furnished to Mr. Loskor, learned counsel for the petitioner, so that he may obtain necessary instruction in this regard. Rest the matter in the second week of January.
Lordship,
The
my-
letter furnished before the court today be marked, shall be marked as Annexure A and B and B.
Lordship, my contention is,
Check
that,
with
my
the
lord,
court.
they considered my first betterment certificate, second betterment certificate, why not second betterment certificate?
No, another thing is
Both-
that the process has already been completed. There is no stay order operating. What purpose will be served by proceeding with this petition now?
And also, as for notification, only one betterment is allowed. That notification is there, we have annexed to the federal. Obliged.
Yes.
Most of them.
I want to just mention one thing. Item 25. Whether it's the fact was on name, but not showing the process well.
Mm.
My lord, last occasion, your lordship has asked me with regard to the maintainability. To in this regard, my lord, I have produced, I brought some judgments to place before the lordship.
Mm.
Whether the third party can, who is not the party in the original read petition, my lord, whether he can file a review petition against the order.
Mhm.
The answer is yes, my lord. Any
But
part,
you ought to have filed one IA in that original petition perhaps.
lordship? Yeah.
I have seen
Yeah,
in some of the
lordship, IA is
cases.
there. IA is on for granting us permission to remove the review petition.
Matlab, take up this matter on month of January, matlab, and our name may be reflected. on SC.
January.
Yes, SC high.
Okay. So somehow you are here. Okay. As agreed by learned advocates of both the parties, raise the matter in the third week of January. Third week of January. Recess shall also reflect the name of the learned standing council of higher education
20th January.
in the cause list.
It will be on 20th January, my lord. 20th January,
Tuesday.
Tuesday.
28.
20.
28 Wednesday. On 27.
Okay.
On 27 is Tuesday.
Okay. Document again?
I don't know, 2 p.m. Are we done here? That's the payment fixes. Item 28 for hearing.
May I please your lordship, Lord, with apology, my lord. Because I made a mention before the learned, my lord, code number 4, yesterday, my lord, that was permitted, my lord, for listing tomorrow, my lord. But the fact is that, my lord, on account of some objections, my lord, I have to replace some pages. And the notary who passed the, my lord, earlier petition, he is on leave, my lord, he is not had, he had Guwahati, my lord. So she is coming tomorrow. So maybe I may pray that, my lord, I may be, matter may be listed on 19, my lord.
Which matter?
My lord, that matter was permitted by code number 4, my lord.
Mentioned in report number 4.
Mm.
That what is now over.
Mm.
So in relation to that mention, he is mentioned before your lordship's court.
No, where is
Code
the
number 4
provision?
Has already risen, my lord. That is why.
No. This court cannot.
Mine.
28.8.
Your lordship. This matter may be taken after the vacation. Lordship.
After vacation?
Yes, Lordship.
Okay, all right.
So we will be-
Mr. Goswami, learned counsel for the appellant. With consent from the other side, first for listing the matter after vacation. Where allowed, list the matter after vacation.
20 plus, 20th of January, 20.
27, 27. 27, yes.
All right.
I can fix that to PM. I can 27 for orders the vacancy. Right, sir.
I've lost my voice.
Okay, okay.
Because of the weather sense and all the.
Uh-huh.
Lordship, in the RA 3569, Lordship may please come to paragraph 6.
No, yesterday and,
Lordship has called for the record.
yes,
Record.
Mr. Das, so where it is recorded, the reason? Page number. 23 onwards. No, where is the record, where is the finding? Well, yes, regarding his replacement.
What is happened, also the was nominated, he was a nominated member.
Yes.
Minister, by the initial member, the nominated person.
Hmm.
And in that process, there is no criteria for selection of that nominated person.
Hmm.
Now, complaint has been received, complaint has been received by the education minister and the government regarding it is not functioning of it is not properly function the governing body of
Hmm.
and that is associated with some political party also.
Hmm.
After going through this matter, the our kindly seek is not guilty. The education minister has
Hmm.
education minister and after going through all this, directed to the education for
Mhm.
the process and suggested the
Okay.
director and the authority to keep the name of the person. And I want to and my submission is specific submission to my law. Since at the time of community
Mm.
selection, there is no criteria for selection as such.
Mm.
And he has been nominated from among many others.
Mm.
This is also when the government finds and there is complaint against a person. So there will be no necessary for any inquiry or
Okay. So on the basis of the note furnished by the Minister of Education, he has been removed from the presidency. Okay. This is the original file.
actually in the E5 is the
Printout. Okay. Yes.
So may I please, Lordship, may please come to page 9 of my IA 3569.
Now, Mrs. Sharma, you tell me on which date the petitioner was removed from the presidency of the GB of Demoria College?
26, 25 minutes.
26 to
20
26.
06 2025. 2026.
Twenty-eight, 6, 2025.
Yes, ma'am.
28.
And on who is that this interim order was passed?
22nd of.
When the interim order?
22nd of August.
2nd of August.
So what is the ground for delay?
Madam, that is stated in paragraph. My lord takes up the writ petition. Madam, may kindly take up the writ petition for a moment.
Paragraph 8 at page 18.
Page
He has
18.
given the reason.
Page number.
18,
Page
paragraph
number.
8,
Page number.
Page 18 of the writ petition also. The petitioner will be discussing his duties and all that. Then the respondent calls for it. However, as a matter of reminds that on 29/7/25, the petitioner received a message by WhatsApp by the principal of the respondent college containing two numbers of communication dated 26/25 and 36/25. And the repetition is filed Lordship on 19th of August 2025.
So where you have explained?
Paragraph 8, my lord, page 18. However, my lord, the interim order was granted because of non-compliance of natural justice and that no reasons were assigned for his replacement. It has been clearly explained, my lord, the delay. In fact, my lord, the order which has been impugned by which the petitioner was removed was not even marked to the petitioner, my lord. My lord may produce the impugned order. It was done unilaterally behind the back of the petitioner. My lord. Once my learned senior friend completes, my lord, I'll submit on.
Lordship, many times it was argued, Lordship, that it was not communicated to him when he was disturbed. And when he was nominated, then also it was not communicated to him. The rule is it is sent to the principal informed. Because he himself has annexed the document laws by which he was appointed. There also, there was nothing, it was not communicated to him. Page 35, Annexure C. Of the writ petition, madam. Which may not be visible, Lordship, I do not know. My lord, if it is not given a type copy also.
If there
Somehow type copy is not given anyway, Lordship, if my lord. So, but this type copy is there at page 99 of my IA, Lordship. I have given a type copy at page 99 of this document, Lordship. Original copy I have given. At page 99, Annexure C.
Okay, in
So this
petition,
page
it is page 35 and Annexure C.
Yes. This is the appointment also. As chairperson. As chairperson. On 27/1/25, 15/31/28. Time. It was from the Additional Secretary to the Government of Assam. It was to the Principal, Dimoria College Autonomous. A copy was given to the Director, to the PS, Honorable Minister Education, to PS Secretary Higher Education. It was never communicated to him. But the minister is always communicated, Lordship, when someone is appointed, Lordship. So that Lordship can take note, this page 35, the fair copy Lordship would get at page 99, Annexure 6 of my IA.
Because this is not legible, Lordship.
No, no, this type copy is legible here.
Type copy is there, my lord, page 35,
Mhm.
annexure C. No, in my copy it is not there. So sorry, Mr. Gulati. No, no, it's all right, no problem. I have the original, so I have no problem. In my petition.
So you are only nominated member, nominated president of the GBA of Demoria College.
Yes, ma'am. Is nominated.
Hmm.
I'll,
So,
I'll place certain facts once my learned.
No,
senior-
you don't have any statutory right over the
No, that is,
the post.
that is incorrect, my lord. I'll come, I've
Hmm.
equipped with judgments
Hmm.
and also I'll explain, my lord, if my learned, may I start, my lord?
Hmm.
My lord, so far what I've understood from the submission made by my learned senior friend, my lord,
Hmm.
for vacating the stay order, is that, my lord, first, my lord, my learned senior friend is urged, my lord, that Assam Provincialized College and Assam Non-Government College Management Rules 2001,
Hmm.
that is applicable to the present case.
Hmm.
And in that rule, in that particular rule, there is a provision which says, my lords, that a person cannot be a political person. He has to be a non-political person. Now, my lords, first, my lord would test whether that rule, that 2001 rule, is applicable or not. Now my submission is twofold in that regard.
No,
my lord.
is it presently not in force?
No, it's not applicable at all. That is why, my lords, I'll very briefly narrate the history, my lords.
Hmm.
This Demoria College, my lords, it was a provincialized college which was aided by the government,
Hmm.
like normal colleges, my lord, provincialized colleges. Now, my lords, if my lord kindly takes up the UGC Act,
Hmm.
the regulation, my lord, for my lord's convenience, I'm giving you a copy. my lord.
Hmm.
Dada. Now, my lords, what had happened, my lords, this UGC regulation
Hmm.
is a regulation framed under the UGC Act, my lords,
Hmm.
which is a central legislation.
Hmm.
Now, my lords, why is this regulation framed? This regulation is framed for conferment of autonomous status upon colleges and measures for maintenance. It's basically, my lords, promulgated for autonomy of colleges for enhancement of quality higher education. Now, what happens, my lord, if a college, if a provincialized college wants to be an autonomous college, there are certain benefits. Like if it's an autonomous college, my lords, they have their own curriculum, for example, my lords. They don't have to rely with the university. They have their own curriculum, they can set their own standards. And to be an autonomous college, this is the, my lords, this rule, this regulation is the regulation, my lords. Once a college applies for autonomous.
No.
Yes, yes.
This regulation never deals with appointment of the.
Yes, exactly. Now, when Demoria College had applied for autonomous status, my lord, under this regulation, in the year
Whether
2024,
that status was granted
in
to
the
the
year
college?
2024, when they fulfilled all the eligibility criteria, they
No,
were.
no. Whether the Demoria College.
Yes,
granted
autonomous. My lord, to see
status?
it's an autonomous college. That is not disputed by my learned senior friend. It's an autonomous college. It has been granted autonomy by virtue of this regulation in the year 2024. Now, my lord would kindly peruse this regulation, my lord. My lord would kindly come to 12.3. 12.3 of the regulation. My lord has it. 12.3 governing body. A. Constitution of governing body run by trust society. We are not concerned with that. My lord would come to B because it was a government college. Constitution of governing body of government colleges. My lord would see there are total 10 members, my lord. First, my lord, 3 members, one of them to be the chairperson. The next column, educationist, industrialist, professional. The third column, nominated by the state government, persons of proven academic interest with at least PG level qualification. Now, my lords, if I may read again, my lords, 3 members, one of them to be the chairperson. Now, what happens, my lords? Once a college is granted autonomy, my lords, the governing body.
No. Do you produce any document in support of the claim that you are the government college?
Oh, that is not disputed, my lord. It is a government college. Yes, that my learned senior friend would also agree. It's a government college which had applied for autonomy, my lords. Now, autonomy was granted under the regulations of UGC. And once it's an autonomous college, there's a governing body which is stipulated by the regulation, and this is the regulation, my lord. 3 members, one of them to be the chairperson. Now, my lord, there are 3 members, my lord. One, an educationist, second, an industrialist, and third, a professional. Now, the state would first nominate 3 members, my lord. I was nominated in the category of educationist. And after the nominations are made, my lords, again, my lords, out of that 3 persons, my lords, one will be appointed as the chairperson. It's in the second column, if my lord peruses. It's in the first column itself. 3 members, one of them to be the chairperson. Accordingly, my lords, on 6/12/2024, my lord, may kindly have page. I'll come to the regulation again, my lords. Page 34 for a moment, my lords, my writ petition. Kindly, my lords. Page 30, first page 33, my lords. Under the regulation, my lords, my lord has 33, page 33, annexure A. Yes. From Geeta Kundu, Additional Secretary to the Director of Higher Education regarding nomination of chairperson and members of governing body of autonomous colleges. In inviting reference to the subject cited above, I am directed that the Government of Assam in Higher Education Department is pleased to nominate 1 educationist, 1 industrialist, 1 professional, and 1 state government nominee for the governing body of the following college. Dhokwa Khana, we're not concerned, my lords. Number 2, Dimoria. Number 1 is Professor Krishna Gopal Bhattacharya, who's the petitioner. He is nominated as an educationist. Number 2, Gautam Haloy, proprietor. He's the industrialist, my lords. And 3, Pranab Kumar Sharma, senior consultant, Indian Institute of Entrepreneurship. He's the professional. Now, if my lord turns the page, my lords, and comes to page 35, because the regulation says, my lords, I would reiterate, my lords, 3 persons to be appointed, nominated by the state: industrialist, professional, and industrialist, professional, and educationist. And out of those 3 persons, 1 has to be nominated as the chairperson. That nomination, my lord, would find again at page 35. In inviting reference, my lord, has it, my lord? 35.
No, why you are repeating the same thing?
Yes. Yes, I have been nominated as the chairperson. Now, if my lord comes to the regulation again, my lord. The regulation, if my lord comes again, my lords, the regulation says, my lords, term. So there is a tenure prescribed to the governing body. The governing body shall be reconstituted every 5 years. My lord has it. My lord may kindly mark it. It's a statutory regulation, and that regulation provides for a tenure which is 5 years. Now, my lords, my learned senior friend, my lords, they had referred to some other alien regulation, rule 2001, and to say that that is applicable. It has been stated in the IA that since, my lords, if my lord comes to after term, meeting, quorum, my lord would find functions of the governing body. My lord has it, my lords. Sub functions of the governing body. My lord, it starts with subject to the existing provisions in the bylaws of respective autonomous colleges and rules laid down by the state government. Rules laid down by the state government. Now, because it says, my lord, subject to the rules laid down by the state government, it is tried to be projected that the 2001 rules, where, my lord, the political person is there, that is applicable. But in my humble submission, my lord, the deepest respect, my lord would see it comes under the heading functions of the governing body. So it means, my lords, only the functions of the governing body can be supplemented by the state rule, which also provides for various other functions of the governing body. Otherwise, there will be a repugnancy. I'll tell why, my lords. I'll submit why. Because the 2001 rules, under the 2001 rules, there is no provision of nominating an industrialist and a professional. Only an educationist has to be there. The members are more. The appointment is made by the director in the 2001 rules. But in the UGC regulation, it is made by the state government. And obviously, my lord, since it's an autonomous college, there are central regulation which provides that once you have the autonomous status, the governing body has to be constituted in terms of the regulation. and accordingly that was constituted. Therefore, my lords, in the first leg of my argument, my lords, the 2001 rules are not applicable in any context, my lords. Now, even assuming for a moment, my lord, before I come to my next point, my lord, even assuming for a moment, my lord, that the 2001 rules are applicable, even assuming for the sake of argument, if my lord takes up that rule for a moment once, my lord, kindly, my lord. It is part of the IA, my lord, that rule. And if my lord comes to page 51, just to show the repugnancy of the 2001 rules, that it cannot be reconciled. How will the 2001 rules be applied, my lord, once the college is autonomous? First, my lord, page 51 is the rules, my lord. My lord. My lord has it. Constitution of governing body. My lord remembers, my lord, as per the regulation, UGC only 10 members. Here, my lord would see, my lord, every college affiliated so and so shall be governing by the governing body. 2. Composition of the governing body. The governing body shall consist of one president who shall be an eminent person in the field of education. So there are no professional and industrialists as envisaged in the regulation, in the UGC regulation. Only one educationist. And who will be appointed? He shall be appointed by the Director of Higher Education. Whereas the regulation prescribes that the state government has to appoint the nominated member, and once they are nominated, a chairman has to be appointed amongst them. So it is different, my lord, and it is not applicable. Now, coming to this political person argument, my lord would come to page 53, where it's there, my lord. President 53, clause 3, my lord. I'm not saying it is applicable. I'm just assuming for a moment, my lord, it is applicable. I'll just read the clause once, my lord. It cannot be interpreted in a way as interpreted by respected senior counsel, my lord. The president of governing bodies of colleges shall be an eminent person in the field of education. All right, my lord. The regulation prescribes professional also. It doesn't matter, my lord. He shall be a non-political person. Stop. Now it says non-political person, and it has been qualified because non-political person, that phrase is a very wide phrase, my lord. I may have political ideologies. My lord may have any political ideology. That does not make a person a political person. Who is a political person? It has been defined in the next lines. He should not have contested any election, including panchayat, municipality, local body election, or should not be an office bearer of any political party, or should not have any affiliation membership to any political party. So a non-political person would mean a person who has not contested any election, panchayat, whatever, should not be he's not an office bearer of any political party, and he does not have any affiliation, membership to any political party. Now that is the correct way of interpretation, my lords. Lordship knows about the Latin term nocitere socis, my lords. A phrase or a word is supported by the supported words, my lords. Because if a non-political person is given a very wide meaning, my lords, I have my own political ideology. That does not mean I'm a political person. So the lawmakers, while drafting this, my lords, has clearly provided who will be a non-political person. And that is what it follows. No election, it should not be an office bearer. So in any case, this is not applicable, but still, I'm just clarifying my point, my lords.
If he becomes the founder of a political party, then
Yes. Now, founder, that is why it has been qualified, my lord. It says a non-political person, my lord. I'm just the sake of argument. Now, what does a non-political person mean, my lord? It is a very vague statement, my lord, isn't it, my lord? A non-political person means a person who does not have any ideology, political ideology. I have a political ideology, my lord. I support a certain party, but that does not make me a political person, my lord. Who's a non-political person? It has been defined. There has to certain things, my lord. Otherwise, my lord, it will be a very, if it is construed the way my learned senior friend wants it, my lord, everyone can be, my lord, branded as a political person, my lord.
No. On the
yes.
On yesterday,
I agree, my lord. My lord is what falls from my lord is, if I'm a founder of a political party, am I not a political person? I agree. Now, my lords, who has alleged that I'm a political person? The allegation has come by way of the interlocutory application. I have filed my objection denying it. Is there any material? Is there any material on record which this court can consider and say, and which proves that I'm the founder of that whatever party, my lord? I'm not known as a person who's affiliated to any political party. I'm known as a person that I'm a renowned educationist, and in fact, I'm one of the 2% of scientists in the world, my lords, and it has been declared by the Stanford University. I'm not someone who's, my lord, dying for the post of.
No, your academic qualification and your experience has not been challenged in this petition.
Yes,
That is not the
exactly.
subject matter
Exactly.
of neither the I nor the writ
Yes.
petition.
So my humble submission with regard to the first argument, by my learned senior friend, that the 2001 rules, my lord, are not even applicable because it's an autonomous college by virtue of that UGC regulation, which is a regulation under the UGC Act and a central legislation, my lords. So this 2001 rules are not at all applicable. Even assuming it is applicable, I am a non-political person, my lords. I've shown why, my lords, because of the interpretation of clause 3, my lords. There are no allegation which says that I have ever contested any elections, or I am a what, my lord, office bearer of a political party, or I have any membership of a political party. In any case, it is not applicable. Now, the second leg of argument is very important, my lords. My learned senior friend has urged, my lords, that since it is a nominated post, I'm nominated. Since it is a nominated post, my lord, petitioner occupies the post only till the pleasure of the government. So nominated post, I agree. In a nominated post, I'll be there till the pleasure of the government. That would have been true. That proposition would have been true provided there was no tenure prescribed to the statute. In both the statute, that UGC also, my lord, 5 years. This 2000 also, if my lord takes into consideration 2001 also, there is a tenure prescribed, my lord.
No,
Yes.
maybe.
Yes, I'll
Even
come
if
to that.
tenure is prescribed, whether the authority is not entitled to remove you.
Exactly not. If a tenure is prescribed, the pleasure doctrine won't apply. And when the pleasure doctrine applies, my lords, natural justice is not followed. That's an established rule. I'll place a judgment just for a moment, my lord. My lord, may I kindly take up 2006 2 GLR 516 to compilation. It's a division bench judgment of this honorable court, my lord. Compilation court. I'll have a copy. I'll provide a copy, my lord. So, nominated post, I have no right. But if there is a tenure prescribed, my lords, then the doctrine of pleasure would not apply and rules of natural justice would apply. It isn't clearly stated, my lord. Yes. Oh, sorry, co-SX. 2006 2 GLR 516, Makhon Pegu. Yes. That is totally correct, my lord. Nominated post, in the absence of a tenure, it's at the pleasure of the government. Here also the consideration was with regard to nomination of missing autonomous council members, my lords. My lord would come to paragraph 1. This appeal raises the following questions. Whether proviso to section 18 of Missing Autonomous Council Act 1995 as amended confers power on the state government to remove members of interim general council or executive council as the case may be appointed under so and so at the pleasure of the government. Whether principles of natural justice are required to be followed before passing orders removing such nominated members of interim general council or executive council as the case may be. Now, what was held, my lord? My lord would come to paragraph 6 directly, my lord. It's a division bench judgment, my lord. Paragraph 6. A bare perusal of the provisions makes it clear that the government is duty bound as soon as possible to take steps for constitution of an interim general council by nomination and to nominate executive council therefrom and to perform duties till the general council is constituted in accordance with the provisions of the act. The whole thing is transitional in nature. The nomination so made as interim general council or to the executive council is not for any particular period. It does not assure any tenure as such. Lordship would mark it. They obviously hold the office during the pleasure of the state government. Precisely for that reason, the proviso confers unfettered discretion upon the government to remove any or all the members of such interim general council or executive council, as the case may be, being replaced by any other persons of the government choice. Hello, Lordship may skip it. Lordship may come to paragraph 9 again. The writ petitioners were nominated as it is evident from the order dated so and so by the governor of Assam while reconstituting the missing autonomous council and the missing autonomous executive council by replacing the earlier one. They had not been appointed for any particular tenure. The order by which they have been nominated is self-explanatory, in which it is implicit that a nominated member holds office during the pleasure of the state government. Yes, when there is no tenure prescribed. If my lord again comes to paragraph 13. Paragraph 13. It is a settled law that the pleasure doctrine relates to a tenure of a person to public office. Tenure means manner, conditions, or term of holding something. According to Webster's Third New International Dictionary, the term holding title authority, according to the Oxford Dictionary, it therefore means the period for which the incumbent of office holds it in the absence of any tenure to hold the office. Lordship would again mark it. The office holder of the office subject to the pleasure doctrine except as expressly provided by the statute. Now, there are plethora of judgments, my lord, which says, my lord, doctrine of pleasure won't apply in cases where the statute provides for a tenure. Now, the UGC regulation admittedly provides a tenure of 5 years, so does the 2001 regulations. So, my lords, by relying on this judgment, at least they cannot say that the rules of natural justice is not applicable. Now, my lords, may kindly take up another judgment of the Guwahati High Court. Dealing with the 2001 rule, JB colleges nominated, my lord, Jugendranath Sharma's case, my lord. Lordship may kindly take it up. Here he was replaced mid-term in the similar fashion like the petitioner. What did the court, my lord? It was report 1 WPC is 550 of 2018. My lord, Jugendra Sharma versus State of Assam. Facts, my lord would find at paragraph 3. I'll just highlight the facts or I can narrate it what had happened, my lord. He was nominated to be the president of the governing body of JB College under the 2001 rules. And during the midterm, he was replaced due to some allegation. And what the court held, my lord, remove after 2 years. My lord would come to paragraph 5. Against the order of removal, the petitioner submitted a representation before the principal secretary of the government of Assam in the higher education department, dated so and so. In the said representation, the petitioner stated his grounds against the order of removal from the post. It is noticed that the order of 30/12/2017 that the petitioner was relieved from the post of president of the concerned college without being issued even a show cause notice. Although the order of removal have been passed on the basis of certain allegations against him, it being the position, the court is of the view that the petitioner was at least entitled a show cause notice so that he can give his reply to such allegations. 7 and 8, my lords, the removal was set aside and the authorities were directed to give an opportunity to the petitioner. Now, my lords, I would like to submit, my lord, this political or non-political debate, my lords, even assuming 2001 is applicable, my lords, was I not entitled to a show cause notice at least? And these allegations, my lords, the order of removal does not provide for any reasons, that itself strikes at Article 14, my lords. It's arbitrary. Courts have held a number of times that a administrative order, there should be reasons assigned. Now, I did not ask for the nomination, my lord. I was nominated. Now, in terms of the judgment, there was a tenure prescribed. And if I was removed mid-tenure, there are civil consequences, my lords. And since it's a tenure post and the Honorable Court has held that a show cause notice must have been issued, ought to have been issued, I was not even issued a show cause notice, my lord. Even assuming I'm a political person, there should have been a show cause notice, my lord. And these allegations, my lord, these allegations, there are counter allegations as well. So, my lords, the contention that since it's a nominated post, that's why there is no requirement of following the principles of natural justice, does not hold any water in my respectful submission. Now, coming to the next point, my lord. And I have also placed Jogendranath Sharma's case, my lord. Exact dicto situation, my lord. The court has set aside the cancellation. Now, my lords. Oh,
No, Mr. Mohanto, you see, we are not hearing the writ petition now.
Yes. No,
We
if
are
my lord
only
wants to
on
make
the
it now,
interim.
yes. What ground is made out by the IA, my lord? First of all, my lord, they are not even the appointing authority.
No, if you want that the writ petition should be disposed
No, my
of,
lord,
then
no, my lord. No, I'm just want dismissal of the IA, my lord. If my interim order is set aside, my lord, I'll be prejudiced, my lord. And no case has been made out. What is their case? They come up with some paper article saying I'm a political member, whereas the 2001 rules does not even apply. The next argument that there should not be any natural justice. That also, I've shown it from the judgments. There is a tenure post, there's a tenure prescribed, there has to be a show cause notice. Thereafter, Jogendranath Sharma's case, exactly similar situation. President of the governing body under the 2001 rules. The court had set aside the removal. Now they have to come up with some concrete grounds, my lords. Their IA is bereft of any grounds, my lords. I would have understood if they were the state, my lords. They're not even the state, the appointing authority. And whatever my learned friend for the state government has urged before your lordship today.
who is not a state?
My lords, they appear for the college, my lords. College is not even the appointing authority. And how do they know why was they privy to the orders, my lords? With the deepest respect, my lord, they are the college. The decision is taken by the state government who will be nominated and will not be nominated. They have come up with an IA. And now my learned friend for the state government has submitted that there were some allegations or whatever. That should be brought on record. At least I should get an opportunity to reply to that, my lord. There is nothing in the order. The order does not say anything. I'm a 74-year-old. I've been nominated. I did not ask for the nomination. I've been nominated to the board. Thereafter, I was appointed as the president of the governing body and I've been removed unilaterally. And now I have come to learn that there are so many allegations against me, my lord. Are they not, is it not the basic tenet of natural justice to give me an opportunity? Now they say that I have not attended the governing body meeting or whatever, my lord.
But whether the rules and regulations applicable to a regular government servant will be applicable in
Yes,
case of you.
exactly. That question has been answered by the division bench judgment, my lord, where it has been clearly said, my lord, where it's a nominated post, my lord. When there is a nomination by the government under a statute, for example, the missing autonomous council, there is a provision for nomination and missing autonomous council members were nominated. That statute or that rule did not have a tenure attached to it. But in our case, with the deepest respect, my lord, 12.3, the governing body has a tenure. Now, my lords, there are a number of judgments.
No.
Yes, if it's a tenure post, even a nominated post, the doctrine of pleasure will not apply. And since doctrine of pleasure will not apply, the rules of natural justice has to be followed. Yes, ma'am. I'm so sorry.
Even if it is a tenure post, whether the respondent authorities are not entitled to remove you.
Of course, my lords, like they have, that's the only ground I agree, my lords. The right to appoint, would obviously mean the right to remove. Right, my lord? I agree to them on that point, my lord. Right to appoint, but those are subject to statutory and constitutional limitations, my lord.
Mm.
BP Single's case, my lord is aware, my lord, the governor Rajasthan.
Mm.
There, my lord, lot of governors were removed, and the central government had filed an affidavit saying it's doctrine of pleasure. It's our pleasure. But the Honorable Supreme Court has held, I have the judgment, my lord,
No,
that
that's
the
a second.
discretion
Mm.
cannot be whimsical.
Mm.
It has to be based on some reason.
Mm.
And that reasons have to be at least communicated. Now, now what I'm trying to put forth, my lords, I have been removed midterm. My lord agrees,
Mm.
5 years tenure. I have been removed midterm. That removal midterm has civil consequences, at least. It has civil consequences. And the Supreme Court, time and again, my lord, Binapani Day's case, my lord, it says if there's a civil consequences, the principles of natural justice has to be followed. Now that would not have been a requirement if there was no tenure attached, because the Honorable Guwahati High Court and the Supreme Court time and again has said that in nominated post, if there is no tenure, then the state has the pleasure and no natural justice should be afforded. But in our case, there's a tenure provided, and there's another additional ground. They say, had it been a case that there was no allegation against me, no allegation against me, they just removed me and replaced me with someone else. Even then also, my lords, okay, because there's no allegation. Now there are allegations that I did not attend. I'm a political person. So there has been inquiries made behind my back, my lords. I was not even made aware of those inquiries. In such cases, my lord, can this court dispense with the rules of natural justice, my lord?
No, you see, we are not
Yes.
hearing the writ petition. We are on the IA.
Yes. Now in the IA, why was the interim order passed?
Mr.
Sorry, ma'am.
Mr. Mohanto, you see, while passing this order,
yes,
interim order,
yes,
whether the principle of granting interim relief is discussed here.
Yes, it is there, my lord. I'll read it out, my lord. I haven't get. I haven't get. No. I haven't. My lord, I just got the idea. I'll read the. There, my lord, it was pointed out. Heard Mr. P. Mohanto, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for issuance of appropriate so and so, on the ground that the petitioner was nominated of the governing body of the Moria College by so and thereafter he was nominated and appointed as the chairperson of the governing body of the Moria College by the order dated so and so. However, while the petitioner was discharging his duties as a chairperson of the governing body, he was informed through WhatsApp communication that respondent number 6 has been appointed as the president of the governing body without any show cause notice. So natural justice has been considered or intimation given to the petitioner. The learned counsel submits that it is the violation of the UGC so and so regulations 2023, wherein at regulation 12, the term of 5 years has been prescribed by the governing body and the members. Aggrieved by the subsequent nomination issued without a formal show cause notice and without petitioner being officially informed, hence the writ petition has been filed. Now, it satisfies all the 3 tenets of granting an injunction or an interim order, my lord. There's a prima facie case, no show cause notice. No show cause notice. Second, my lord, the court observed that it had a tenure attached to it. So midterm, he was removed.
Okay.
And my lord, what are the grounds? I didn't see any grounds for vacation. They are the college, my lord. They're not even the state, my lord. The state could have urged those grounds, my lord. There are no grounds. What my learned senior friend had urged, my lord, that I'm a political person by relying on certain newspaper articles, that 2001 rules are not even applicable, my lord. Second, a casual statement has been made that the function of the college is not going on, my lord. There are counter allegations. Lordship would take my objection. I have, my lord. I'll place it, my lord.
Okay. Mr. Sharma. Yes. You please go through these 2 decisions and you come with answers. We will fix it on
After vacation, my lord, after vacation, kindly, my lord. The matter has been,
5 minutes, within 5 minutes I'll give the reply.
Pardon?
Then 5-10 minutes I'll give the reply, Lordship. Because this stay order is, Lordship, this is against the public interest, Lordship. That is what I'm saying. The college is suffering, Lordship. In the order, Siliguri municipality is even not being complied with in the interim order, Lordship. Nothing, Lordship, prima facie, balance of convenience, irreparable loss, public interest, nothing will discuss.
No.
Only because
though,
there is
no.
an interim order is given.
No, Mr. Sharma, you see, though the terms have not been mentioned here, but in substance it may be there.
No.
Examine the matter.
Lordship, the point is,
Hmm.
what right he has to file. First, you have to satisfy the local.
that I already pointed out, my lord, the right.
No.
Sorry.
You come prepared on Thursday.
Third month.
Thursday.
Huh?
Vacation. Okay.
Well, after vacation, my lord, the day of reopening.
We are suffering.
My lord, winter break is going on, my lord. Winter break is going on, my lord. Colleges are closed. After vacation, my lord.
10 minutes, Lord. Not more.
Okay, Thursday.
And let the state also file their affidavit. That is very necessary, my lord. I need to file a reply.
Here, they can file a small affidavit.
On Thursday, I have some
You will file an
reservations.
affidavit, he will take that.
Of
for
course,
my
my lord,
reply.
the
Record
state
is
has,
there already been.
the appointment has been made by the state. They have removed me. Is it not the state who should file the affidavit, my lord? I should get a chance to reply to their affidavit, my lord. These, what have been placed before your lordship, I have not seen those documents, my lord. Let them file an affidavit. My lordship would take it immediately on the day of reopening, my lord. I've got no
I can
problem.
be disposed of, Lordship will dispose of the petition. Any question?
Yes, sir. Mr. Das, are you interested to file your affidavit here?
In the petition, maybe petition.
Yes. Lordship may dispose of
Not
the
like-
entire matter.
You are not going to file your reply here. Okay, Thursday. Third, Mr. Mohanto, learned. No,
My lord,
Mr.
Thursday there is some issues, my lord. Lordship may take it on Friday then, Friday.
No, Friday may not be possible. We have already fixed a lot of cases. Friday.
But then after vacation, my lord, kindly, my lord, it's
No.
2-3 dates, my lord, has been prolonging, my lord, the matter there.
I normally.
Sometime they would also
My
file.
learned friend know me, Lordship. I normally never press to fix a matter.
Hmm.
There is some public interest, students are suffering, professors are suffering, everybody, Lordship.
Okay.
And he's a person not holding a single meeting, Lordship, after the.
Okay. Heard Mr. S. Sharma, learned senior counsel assisted by Mr. Learned counsel for the petitioner. Mr. P. Mohanto, learned counsel for the opposite party number 1. Mr. Das, learned standing counsel for the higher education department. Ms. Barpuzari for respondent number 5. Mr. T.K. Bhuya for respondent opposite party number 6. Heard in part. List the matter on Thursday. In the meantime, Mr. Sharma, learned senior counsel for the applicant, shall go through the decision referred by Mr. Mohanto, learned counsel for the opposite party, and advance his argument on the points so raised by Mr. Mohanto today. List accordingly.
My lord, the state has filed some papers, my lord, the reasons. Can we also get a copy just to know what are the reasons, my lord? So that.
No, these are the this is the file. These are produced before the court as per direction of this court.
Yes.
So we'll not grant you to go through these documents.
Right.
It may be confidential also. As per direction of this court, he has produced it. And not by way of an affidavit.
Yes.
Had it been the part of affidavit, then definitely
Yes.
you would have get one copy.
Thursday then.
Thursday.
DP of like.